5-minute rule. I now recognize the gentleman from Wisconsin, Mr. Sensenbrenner. Mike. Let me repeat that. The committee will come to order. When we broke for recess, we were under the 5-minute rule. I now recognize Mr. Sensenbrenner for 5 minutes to question the witnesses.
Thank you very much, Mr. Chairman. I'm a veteran of impeachments. I've been named by the House as an impeachment manager in 4 impeachments, Clinton and 3 judges. That's more than anybody else in history. And one of the things in every impeachment, whether it's the ones that I was involved in or others that have come before the committee where I was not a manager, is a debate on what is a high crime and misdemeanor and how serious does that have to be in order for it to rise to a level of an impeachable offense. About 50 years ago, then Republican leader Gerald Ford made a comment that saying a high crime and misdemeanor is anything a majority of the House of Representatives deems it to be on any given day. I don't agree with that. You know, that sets either a very low bar or a non-existent bar, and it certainly would make the president serve at the pleasure of the House, which was not what the framers intended when they rejected the British form of parliamentary democracy, where the prime minister and the government could be overthrown by a mere vote of no confidence in the House of Commons. So I'm looking at what we're facing here. This whole inquiry was started out by a comment that President Trump made to President Zelensky in the July 25th call of, quote, "do me a favor," unquote. There are some who have said it's a quid pro quo. There are some who have implied that it's a quid pro quo. But both Trump and Zelensky have said it wasn't, and Zelensky has said there was no pressure on me, and the aid came through within 6 weeks after the phone call in question was made. Now, you can contrast that to where there was no impeachment inquiry to Vice President Biden when he was giving a speech and said, you know, I held up $1 billion worth of aid unless the prosecutor was fired within 6 hours. And son of a bleep, that's what happened. Now, you know, it seems to me that if you're looking for a quid pro quo and looking for something that was really over the top, it was not saying, do me a favor. It was saying, son of a bleep, that's what happened in 6 hours. Now, you know, the Republicans who were in charge of Congress at the time Biden made that comment, we did not tie the country up for 3 months and going on 4 now, wrapping everybody in this town around the axelrod. We continued attempting to do the public's business. That's not what's happening here. And I think the American public are getting a little bit sick and tired of impeachment, 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 when they know that less than a year from now, they will be able to determine whether Donald Trump stays in office or somebody else will be elected. And I take this responsibility extremely seriously. You know, it is an awesome and very grave responsibility, and it is not one that should be done lightly. It is not one that should be done quickly, and is not one without examining all of the evidence, which is what was done in the Nixon impeachment and what was done largely by Kenneth Starr in the Clinton impeachment. Now, I'd like to ask you, Professor Turley, because your mind is the only one of the 4 of you up there that doesn't seem to have it made up before you walked into the door. Isn't there a difference between saying, quote, do me a favor, and, quote, son of a bleep, that's what happened in 6 hours' time?
Grammatically, yes. Constitutionally, it really depends on the context. I think your point is a good one in the sense that we have to determine from the transcript and hopefully from other witnesses whether this statement was part of an actual quid pro quo. I guess the threshold question is, if the president said, I'd like you to do these investigations, and by the way, I don't group them together. In my testimony, I distinguish between the request for investigations into 2016 from the investigation of the Bidens. But it is an issue of order, the magnitude of order constitutionally, if you ask, I'd like to see you do this, as opposed to, I have a quid pro quo, you either do this or you don't get military aid.
Thank you.
Time of the gentleman has expired. The gentlelady from Texas, Ms. Jackson-Lee.
Thank you, Mr. Chairman, for yielding. Professor Gerhardt said, if what we are talking about today is not impeachable, then nothing is impeachable. I'm reminded of my time on the House Judiciary Committee during the 1990s impeachment, and as well, a number of federal judges. I was guided then not only by the facts, but by the Constitution and the duty to serve this nation. I believe, as we greet you today, that we are charged with a sober and somber responsibility. So, Professor Carlin, I'd like you to look at the intelligence volume where hundreds of documents are behind that in the Mueller report. Professor Carlin, you studied the record. Do you think it is, quote, wafer thin? And can you remark on the strength of the record before us?
So obviously it's not wafer thin. And the strength of the record is not just in the the July 25th call. I think the way you need to ask about this is, how does it fit into the pattern of behavior by the president? Because what you're really doing is you're drawing inferences here. This is about circumstantial evidence as well as direct evidence. That is, you're trying to infer, did the president ask for a political favor? And I think this record supports the inference that he did.
What comparisons, Professor Carlin, can we make between kings that the framers were afraid of and the president's conduct today?
So kings could do no wrong because the king's word was law. And contrary to what President Trump has said, Article 2 does not give him the power to do anything he wants. And I'll just give you one example that shows you the difference between him and a king, which is the Constitution says there can be no titles of nobility. So while the president can name his son Baron, he can't make him a baron.
Thank you. The founding father, George Mason, asked, shall any man be above justice? And Alexander Hamilton wrote that high crimes and misdemeanors mean the abuse or violation of some public trust. As we move quickly, Professor Feldman, you have previously testified that the president has abused his power. Is that correct?
Yes, ma'am.
What do you think is the most compelling evidence in this impeachment inquiry that would lead you to that?
The phone call itself of July 25th is extraordinarily clear to my mind in that we hear the president asking for a favor that's clearly of personal benefit rather than acting on behalf of the interests of the nation. And then further from that, further down the road, we have more evidence which tends to give the context and to support the explanation for what happened.
Professor Carlin, how does such abuse affect our democratic systems?
Having foreign interference in our election means that we are less free. It is less we, the people, who are determining who's the next winner than it is a foreign government.
I think it is fair to say that the president's actions are unprecedented. But what also strikes me is how many Republicans and Democrats believe that his conduct was wrong. Let's listen to—
It is improper for the President of the United States—
Listen to the Colonel.
It is improper for the President of the United States to demand a foreign government investigate a U.S. citizen and a political opponent.
Professor Feldman, in light of the fact that the president asked for an investigation and then only when he was caught released the military aid, is there still a need for impeachment?
Yes, ma'am. Impeachment is complete when the president abuses his office, and he abuses his office by attempting to abuse his office. There's no distinction there between trying to do it and succeeding in doing it, and that's especially true if you only stop because you got caught.
Over 70% of the American people believe, as I said, what the president did was wrong. We have a solemn responsibility to address that, and as well, our fidelity to our oath and our duty. I'm reminded of the men and women who serve in the United States military, and I'm reminded of my 3 uncles who served in World War II. I can't imagine them being on the battlefield, needing arms and food, and the general says, "Do me a favor." We know that general would not say, "Do me a favor." And so in this instance, the American people deserve unfettered leadership, and it is our duty to fairly assess the facts and the Constitution. I yield back my time.
Gentlelady yields back. Mr. Shabbat is recognized.
Thank you, Mr. Chairman. It's pretty clear to me that no matter what questions we ask these 4 witnesses here today, and no matter what their answers are, that most, if not all, of the Democrats on this committee are going to vote to impeach President Trump. That's what their hardcore Trump-hating base wants, and they've wanted that since the president was elected 3 years ago. In fact, when Democrats took over the House, one of the first things that they did was introduce articles of impeachment against President Trump, and that was way before President Trump and the Ukrainian President Zelensky ever had their famous phone call, whether it was perfect or not. Now, today, we're undertaking a largely academic exercise instead of hearing from fact witnesses like Adam Schiff or Hunter Biden, but we're not being permitted to call those witnesses. It would seem that since Schiff, for example, misled the American people on multiple occasions, common sense and basic fairness would call for Schiff to be questioned about those things, but we can't. Mr. Chairman, back in 1998, when another president, Bill Clinton, was being considered for impeachment, you said, and I quote, "We must not overturn an election and impeach a president without an overwhelming consensus of the American people and their representatives in Congress." You also said, quote, "There must never be a narrowly voted impeachment or an impeachment substantially supported by one of the major political parties and largely opposed by the other." You said such an impeachment would lack legitimacy, would produce divisiveness and bitterness in our politics for years to come, and will call into question the very legitimacy of our political institutions. That's what you said back then, Mr. Chairman. Well, what you said should never happen, that we should never do, is exactly what you're doing now, moving forward without a consensus and impeachment by one major party that's opposed by the other. And it's almost certain that it's going to result in the very divisiveness and bitterness that you so accurately warned us about back then. Mr. Chairman, a couple more quotes from a very wise Jerry Nadler from about 2 decades ago. Quote, "The last thing you want, it's almost illegitimate, is to have a party line impeachment. You shouldn't impeach the president unless it's a broad consensus of the American people." Those were wise words, Mr. Chairman, but you're not following them today. And finally, again, your words back then, the issue in a potential impeachment is whether to overturn the results of a national election, the free expression of the popular will of the American people. That is an enormous responsibility and an extraordinary power. It is not one we should exercise lightly. It is certainly not one which should be exercised in a manner which either is or would be perceived by the American people to be unfair or partisan, unquote. Again, Mr. Chairman, those things that you warned against then are exactly what you and your Democratic colleagues are doing now. You're about to move forward with a totally party line impeachment. That is clearly not a broad consensus of the American people. You're overturning the result of a national election, and there's no doubt that it will be perceived by at least half of the American people as an unfair and partisan effort. You seem bound and determined to move forward with this impeachment, and the American people deserve better. I get it. Democrats on this committee don't like this president. They don't like his policies. They don't like him as a person. They hate his tweets. They don't like the fact that the Mueller investigation was a flop. So now you're going to impeach him. Well, I got news for you. You may be able to twist enough arms in the House to impeach the president, but that effort's going to die in the Senate. The president's going to serve out his term in office and in all likelihood be reelected to a second term, probably with the help of this very impeachment charade that we're going through now. And while you're wasting so much of Congress's time and the American people's money on this impeachment, there are so many other important things that are going undone. Within this committee's own jurisdiction, we should be addressing the opioid epidemic. We could be working together to find a solution to our immigration and asylum challenges on our southern border. We could be protecting Americans from having their intellectual property and jobs stolen by Chinese companies. And we could be enhancing election security, just to name a few things. And Congress as a whole could be working on rebuilding our crumbling infrastructure, providing additional tax relief to the nation's middle-class families, and providing additional security to our people here at home and abroad. Instead, here we are spinning our wheels once again on impeachment. What a waste. The American people deserve so much better. I yield back.
Gentleman yields back. Mr. Cohen.
Thank you, Mr. Chair. I take no pleasure in the fact that we're here today. As a patriot who loves America, it pains me that the circumstances force us to undertake this grave and solemn obligation. Nonetheless, based simply on the publicly available evidence, it appears that President Trump pressured a foreign government to interfere in our elections by investigating his perceived chief political opponent. Today, we are here to uphold our oaths to defend the Constitution of the United States by furthering our understanding whether the President's conduct is impeachable. It is entirely appropriate that we're examining our nation's history as it relates to presidential impeachment. The framers of the Constitution legitimately feared foreign interference in our nation's sovereignty, and they wanted to ensure that there would be a check and balance on the executive. We sit here with a duty to the founders to fulfill their wisdom in being a check on the executive. We, the People's House, are that check. Under our Constitution, the House can impeach a president for treason, bribery, or other high crimes and misdemeanors. Professor Feldman, you've discussed high crimes and misdemeanors and the fact that the high refers to both crimes and misdemeanors. Can you just give us a little bit of a summary of what high crimes and misdemeanors are and how they're distinct from what Professor Turley said they were?
Yes, sir. High crimes and misdemeanors are actions of the president in office where he uses his office to advance his personal interests for personal gain, potentially to corrupt the electoral process, and potentially as well against the national security interests of the United States. I would add, sir, that the word high modifies both crimes and misdemeanors. The framers' world knew of both high crimes and high misdemeanors. And I believe that the definition that was posted earlier of misdemeanor was not the definition of high misdemeanor, which is a specific term understood by the framers and discussed in the Constitutional Convention, but only of the word misdemeanor. And that's an easy mistake to make, but the truth is that high misdemeanors were their own category of abuses of office, and those are the things that are impeachable.
Thank you, Professor. Professors Feldman, Carlin, and Gerhardt, you've all testified the President's conduct here implicates three categories of high crimes and misdemeanors: abuse of power, betrayal of the national interest, and corruption of elections. Is that right, Professor Carlin?
Yes, it is.
And Professor Feldman and Professor Gerhardt, do you agree?
Yes.
Yes, sir.
Professor Carlin, you stated that the essence of an impeachable offense is the President's decision to sacrifice the national interest for his own private ends. Professor Feldman and Gerhardt, do you all also agree with that?
Yes, sir.
Yes.
Based on the evidence you've seen, Professors Feldman, Carlin, and Gerhardt, has President Trump sacrificed the country's interest in favor of his own? Professor Carlin?
Yes, he has.
And is there a particular piece of evidence that most illuminates that?
I think what illuminates that most for me is the statement by Ambassador Sondland that he wanted simply the announcement of an investigation. And several other people said exactly the same thing. There's testimony by Ambassador Volker to this extent as well, that what he wanted was simply public information to damage Joe Biden. He didn't care whether at the end of the day Joe Biden was found guilty or exonerated.
And Professor Feldman, do you agree, or do you have a different or the same illuminating fact?
My emphasis would be on the fact that the president held up aid to an ally that's fighting a war in direct contravention of the unanimous recommendation of the national security community. That, to me, seems to have placed his own interests in personal advantage ahead of the interests of the nation.
And a bill passed by Congress, bipartisan.
Yes, sir.
Professor Gerhardt?
I agree with what my colleagues have said. I would add that I'm very concerned about the President's obstruction of Congress. obstruction of this inquiry, refusal to comply with a number of subpoenas, ordering many high-level officials in the government not to comply with subpoenas, and asking and ordering the entire executive branch not to cooperate with Congress. It's useful to remember the Constitution says the House has the sole power to impeach. The Constitution only uses the word sole twice, once with reference to the House in this area, once with reference to the Senate with respect to impeachment trials. Sole means only. And this is your decision.
And let me get Professor Turley into this. Professor Turley, you're a self-described, self-anointed defender of Article I Congress guy. But you justify a position that says legally issued subpoenas by Congress enforcing its powers don't have to be complied with. It seems in this circumstance you're an Article II executive guy. You're talking about the Johnson impeachment is not very useful. That was maladministration. This is a criminal act. Thank you, professors, for helping us understand high crimes and misdemeanors. We, the people's representatives in the People's House, are heirs and custodians of the founders' vision of this country where the people are sovereign. We have a high responsibility and charged with the sole power to uphold our Constitution and defend our democracy, and we shall do that.
The gentleman's time has expired. Mr. Gomer.
Thank you. I'm afraid this hearing is indicative of the indecency to which we've come when instead of the Committee of Jurisdiction bringing in fact witnesses to get to the bottom of what happened, and not even having time to review the report, which, as Professor Turley indicated, is wafer thin when compared to the 36 boxes of documents that were delivered to the last impeachment group. But then to start this hearing with the chairman of the committee saying that the facts are undisputed, the only thing that is disputed more than the facts in this case is the statement that the facts are undisputed. They are absolutely disputed, and the evidence is a bunch of hearsay on hearsay that if anybody here had tried cases before of enough magnitude, you would know you can't rely on hearsay, but we have experts who know better than the accumulated experience of the ages. So here we are. And I would submit we need some factual witnesses. We do not need to receive a report that we don't have a chance to read before this hearing. We need a chance to bring in actual fact witnesses. And there are a couple I can name that are critical to us getting to the bottom. They work for the National Security Council, Abigail Grace, Sean Misko. They were involved in the U.S.-Ukraine affairs, and they worked with Vice President Biden on different matters involving the Ukraine. They worked with Brennan and Masters. They have absolutely critical information about certain Ukrainians' involvement in our U.S. election. Their relationships with the witnesses who went before the Intel Committee and others involved in these allegations make them the most critical witnesses in this entire investigation. And their records, including their emails, their text messages, their flash drives, their computers, have information that will bring this effort to remove the president to a screeching halt. So we have an article here from October 11th. Kerry Pickett points out that House Intelligence Committee Chairman Adam Schiff recruited 2 former National Security Council aides who worked alongside the CIA whistleblower at the NSC during the Obama and Trump administrations. Abigail Grace, who worked at the NSC until 2018, was hired in February, while Sean Misko, an NSC aide until 2017, joined Schiff's committee in August, the same month the whistleblower submitted his complaint. And goes on to point out that Grace was hired to help Schiff's committee investigate the Trump White House. That month, Trump accused Schiff of stealing people who were working at the White House. And Chairman Schiff said, if the president's worried about our hiring any former administration people, maybe he should work on being a better employer. No, he should have fired everybody, just like Bill Clinton did, all the U.S. attorneys on the same day. That would have saved us a lot of what's going on here. So anyway, we need those 2 witnesses. They're critical. And then we also need someone who is a CIA detail lead at the Ukraine NSC desk. State Department FOIA shows that he was at an Italy state luncheon. There's Italy ramifications in the last elections. He speaks Arabic and Russian, reported directly to Charles Kupchan, who's a friend of the Clintons' aide, Sid Blumenthal. He did policy work for Ukraine corruption. Close continuous contact with the FBI state Ukrainian officials, had a collateral duty to support Vice President Biden. And Biden was Obama's point man on Ukraine. He was associated with DNC operative Ali Chalupa, who we also need. Met with her November 9, 2015, with the Ukrainian delegation. And there's all kinds of reasons we need these 3 witnesses, and I would ask, pursuant to Section 4, House Resolution 660, ask our our ranking member to submit the request for these 3 witnesses, because we're not having a factual hearing until we have these people that are at the bottom of every fact of this investigation.
Gentleman's
I yield
time is-
back. Thanks for
Gentleman's-
bringing down the gavel,
Gentleman-
Hart. That was nice.
The gentleman yields back. Mr. Johnson.
Thank you, Mr. Chairman. The President has regularly and recently solicited foreign interference in our upcoming elections. Professor Turley warns that this is an impulse buy moment and suggests that the House should pause. Professor Carlin, do you agree with Professor Turley?
No, if you conclude that, as I think the evidence to this point shows, that the president is soliciting foreign involvement in our election, you need to act now to prevent foreign interference in the next election like the one we had in the past.
Thank you. Professor Carlin, in 30 seconds or less, tell us why you believe the president's misconduct was an abuse of power so egregious that it merits the drastic remedy of impeachment.
Because he invited the Russians, who are our longtime adversaries, into the process the last time around, because he has invited the Ukrainians into the process, and because he suggested he would like the Chinese to come into the process as well.
Thank you very much. One of the framers of our Constitution, Edmund Randolph, who at one time was mayor of Williamsburg, Virginia, warned us that, quote, the executive will have great opportunities of abusing his power, end quote. Professor Feldman, people like Mayor Randolph rebelled because of the tyranny of a king. Why were the framers so careful to avoid the potential for a president to become so tyrannical and abusive? And what did they do to protect against it?
The framers believed very strongly that the people were the king, the people were sovereign, and that meant that the president worked for somebody, he worked for the people. They knew that a president who couldn't be checked, who could not be supervised by his own Justice Department, and who could not be supervised by Congress and could not be impeached, would effectively be above the law and then would use his power to get himself reelected. And that's why they created the impeachment remedy.
Thank you, Professor Feldman. I now want to discuss how the framers' concerns about abuse of power relate to President Trump's misconduct. On July 25th, President Trump said to President Zelensky, quote, I would like you to do us a favor, though. Professor Feldman, when President Trump made use of the words favor, though, do you believe that the president was benignly asking for a favor? And how is the answer to that question relevant to whether the president abused his power?
It's relevant, sir, because there's nothing wrong with someone asking for a favor in the interest of the United States of America. The problem is for the president to use his office to solicit or demand a favor for his personal benefit. And the evidence strongly suggests that given the power of the president and given the incentives that the president created for Ukraine to comply with his request, that the president was seeking to serve his own personal benefit and his own personal interest. That's the definition of corruption under the Constitution.
Other witnesses have also testified that it was their impression that when President Trump said, I would like you to do us a favor, though, that he was actually making a demand and not a request. Professor Feldman, how does Lieutenant Colonel Vindman's testimony that the president's statement was a demand because of the power disparity between the two countries relate back to our framers' concerns about the president's abuse of power?
Lieutenant Colonel Vindman's observation states very clearly that you have to understand that the President of the United States has so much more power than the President of Ukraine, that when the President uses the word favor, the reality is that he's applying tremendous pressure, the pressure of the power of the United States. And that relates to the constitutional abuse of office. If someone other than the President of the United States asked the President of Ukraine to do a favor, the President of Ukraine could say no. When the President of the United States uses the office of the presidency to ask for a favor, there's simply no way for the President of Ukraine to refuse.
Thank you. We've also heard testimony that the president withheld a White House meeting and military aid in order to further pressure Ukraine to announce investigations of Vice President Biden and the 2016 election. Professor Carlin, is that why your testimony concluded that the president abused his power?
I thought the president abused his power by asking for a criminal investigation of a United States citizen for political ends, regardless of everything else. That's just, it's not icing on the cake. It's what you would call an aggravating circumstance that there was need here.
All right, thank you. A president holding an American ally over a barrel to extract personal favors is deeply troubling. This is not an impulse buy moment, it's a break the glass moment, and impeachment is the only appropriate remedy, and with that, I will yield back.
The gentleman yields back. Mr. Jordan.
Thank you, Mr. Chairman. Before Speaker Pelosi announced the impeachment inquiry 10 weeks ago on September 24th, before the call between President Trump and President Zelensky on July 25th, before the Mueller hearing in front of this committee on July 24th, before all that, 16 of them had already voted to move forward on impeachment. 16 Democrats on the Judiciary Committee had already voted to move forward on impeachment, yet today we're talking about whether the positions they've already taken are constitutional. Seems a little backward to me. I mean, we can't get agreement. I mean, we got four Democrats or 4 people who voted for Clinton, and they can't agree. Yet today we're talking about the Constitution. Now, Professor Turley, you've been great today, but I think you were wrong on one thing. You said this is a fast impeachment. I would argue it's not a fast impeachment. It's a predetermined impeachment. Predetermined impeachment done in the most unfair partisan fashion we have ever seen. No subpoena power for Republicans. Depositions done in secret, in the bunker, in the basement of the Capitol. 17 people come in for those depositions. No one could be in there except a handful of folks that Adam Schiff allowed in those depositions. Chairman Schiff prevented witnesses from answering Republican questions. Every Democrat question got answered. Not every Republican question. Democrats denied Republicans the witnesses we wanted in the open hearings that took place 3 weeks ago. And of course, Democrats promised us the whistleblower would testify and then change their mind. And they changed their mind, why? Because the whole world discovered that Adam Schiff's staff had talked to the whistleblower, coordinated with the whistleblower with no firsthand knowledge, bias against the president, who worked with Joe Biden, whose lawyer in January of 17 said the impeachment process starts then. That's the unfair process we've been through. And the reason it's been unfair, let me just cut to the chase. The reason it's been unfair is because the facts aren't on their side. The facts are on the president's side. 4 key facts: will not change, have not changed, will never change. We have the transcript. There was no quid pro quo in the transcript. The 2 guys on the call, President Trump and President Zelensky, both said no pressure, no pushing, no quid pro quo. The Ukrainians, third, didn't know that the aid was held up at the time of the phone call. And fourth, and most important, the Ukrainians never started, never promised to start, and never announced an investigation in the time that the aid was paused. Never once. But you know what did happen in those 55 days that the aid was paused? There were 5 key meetings between President Zelensky and senior officials in our government. 5 key meetings. We had the call on July 25th. The very next day, July 26th, we had Ambassador Volker, Taylor, and Sondland meet with President Zelensky in Kyiv. We then had Ambassador Bolton, end of August, meet with President Zelensky. We then had the Vice President meet with President Zelensky on September 1st, and we had 2 senators, Republican and, more importantly, Democrat Senator Murphy with Republican Senator Johnson meet with President Zelensky on September 5th. None of those 5 meetings was aid ever discussed in exchange for an announcement of an investigation into anybody. Not one of them. And you would think the last 2, after the Ukrainians did know the aid was being held, you would think it would come up then, particularly the one where you got Senator Murphy, the Democrat, there talking about it. Never came up. The facts are on the president's side. But we got an unfair process because they don't have the facts. We got an unfair process, most importantly. And this gets to something else you said, Mr. Turley. And this is scary. How mad the country, I mean, that was so well said. This is scary. The Democrats have never accepted the will of the American people. To Mr. Turley's point, 17 days ago, the Speaker of the United States House of Representatives called the President of the United States an imposter. The guy 63 million Americans voted for, who won an electoral college landslide, the Speaker of the United States House of Representatives called that individual an imposter. That is not healthy for our country. This is not healthy. The facts are the facts. They are on the president's side. That's what we need to focus on, not some constitutional hearing at the end of the process when you guys have already determined where you're going to go. With that, I yield back.
The gentleman yields back. Mr. Deutsch.
Thank you, Mr. Chairman. Mr. Chairman, this month we commemorate the 75th anniversary of the Battle of the Bulge. My late father, Bernard Deutsch, then Staff Sergeant Bernard Deutsch, received a Purple Heart fighting in the frigid Ardennes. He gave blood among tens of thousands of Americans who were casualties. They served under officers and a commander-in-chief who were not fighting a war for their own personal benefit. They put country first. They made the same solemn promise that members of Congress and the President of the United States make, to always put national interest above their own personal interest. The evidence shows that the President broke that promise. The Constitution gives the President enormous power, but it also imposes a remedy, impeachment, when those powers are abused. In July, President Trump said, and I quote, "I have an Article 2, where I have the right to do whatever I want as president," close quote. Professor Feldman, the president has broad powers under the Constitution, including in foreign policy, isn't that right?
Yes, sir.
And do those powers mean that the president can do, as he said, whatever he wants as president? Can he abuse the powers that the Constitution gives him?
He may not. If the president uses the powers that he's given for personal gain or to corrupt an election or against the national security interest of the United States, he may be impeached for a high crime and misdemeanor.
Is using his power to pressure Ukraine to interfere in U.S. elections an abuse of that power?
Yes, sir.
Professor Gerhardt, how would the framers of the Constitution have viewed a president asking for election interference from a foreign leader?
It's practically impossible to know exactly what the framers would think, but it's not hard to imagine how the Constitution deals with it. That's their legacy to us. And under the Constitution, it's plainly an abuse of power. It's a rather horrifying abuse of power.
And Professor Carlin, we've heard witnesses over the past several weeks testify about their concerns when the president used his foreign policy powers for political gain. Lieutenant Colonel Vindman was shocked. He couldn't believe what he heard on the phone call. NSC advisor Hill realized that a political errand was diverging from efforts to protect our national security policy. And Ambassador Taylor thought it was crazy to withhold security assistance for help on a political campaign. And Professor Carlin, these concerns aren't mere differences over policy, are they?
No, they go to the foundation, the very foundation of our democracy.
And offering to exchange a White House meeting and hundreds of millions of dollars in security assistance for help with his reelection, that can't be part of our nation's foreign policy, can it?
No, it's the essence of doing something for personal reasons rather than for political reasons. And if I could just say one thing about this very briefly, which is maybe when he was first running for president, he had never been anything other than a reality TV show. That was his public life. Maybe then he could think Russia, if you're listening, is an okay thing to do. But by the time he asked the Ukraine, if you're listening, could you help me out with my reelection? He has to have known that that was not something consistent with his oath of office.
Mr. Chairman, our founders granted the President of the United States enormous powers. But at the same time, what we've been reminded of today, they worry that these powers could be abused by a corrupt president. The evidence of abuse of power in this inquiry proved that our founders were right to be worried. Yes, the president has the power to direct America's foreign policy, but no, he cannot use that power to cheat in our elections. Remember, and I ask all of my colleagues to remember, the Constitution grants the president his power through the American people. The president's source of power is a democratic election. It is the American people, the voters, who trusted him to look out for them. We trusted him to look out for the country. But instead, President Trump looked out for himself in helping himself get reelected. He abused the power that we trusted him with for personal and political gain. The founders worried about just this type of abuse of power, and they provided one way for Congress to respond, and that's the power of impeachment. I yield back.
The gentleman yields back. Mr. Buck.
Thank you, Mr. Chairman. Professor Turley, I want to direct these first few questions to you. The other three witnesses have identified this amorphous standard for impeaching a president. They've said that if a president abuses his power for personal or political gain, it's impeachable conduct. You agree with me?
Not the way it's been stated. In fact, there's so many different standards.
I got a long ways to go here.
Well, there's been so many different standards. One of them was attempting to abuse office.
Okay.
I'm not even sure how to recognize that, let alone define it.
So let me go with a few examples and see if you agree with me. Lyndon Johnson directed the Central Intelligence Agency to place a spy in Barry Goldwater's campaign. That spy got advanced copies of speeches and other strategy, delivered that to the Johnson campaign. Would that be impeachable conduct according to the other panelists?
Oh, well, it sweeps pretty broadly, so I assume so.
How about when President Johnson put a wiretap on Goldwater's campaign plane? Would that be for political benefit?
Well, I can't exclude anything under that definition.
Okay. Well, I'm going to go with a few other presidents. We'll see where we go. Congressman Deutsch just informed us that FDR put country first. Now, Franklin Delano Roosevelt, when he was president, directed the IRS to conduct audits of his political enemies, namely Huey Long, William Randolph Hearst, Hamilton Fish, Father Coughlin. Would that be an abuse of power for political benefit according to the other panelists? Would that be impeachable conduct?
I think it all would be subsumed into it.
How about when President Kennedy directed his brother, Robert Kennedy, to deport one of his mistresses as an East German spy? Would that qualify as impeachable conduct?
Once again, I can't exclude it.
And how about when he directed the FBI to use wiretaps on congressional staffers who opposed him politically? Would that be impeachable conduct?
It would seem to be falling within it.
And let's go to Barack Obama. When Barack Obama directed or made a finding that the Senate was in recess and appointed people to the National Labor Relations Board and lost 9-0, Ruth Bader Ginsburg voted against the president on this issue. Would that be an abuse of power?
I'm afraid you'd have to direct it to others, but I don't see any exclusions under their definition.
Okay, and how about when the president directed his national security advisor and the Secretary of State to lie to the American people about whether the ambassador to Libya was murdered as a result of a video or was murdered as a result of a terrorist act? Would that be an abuse of power for political benefit 17 days before the next election?
Well, not according to my definition. The others will have to respond to their own.
Well, you've heard their definition. You can apply those facts to their definition.
I have a hard time excluding anything out of
How about when Abraham Lincoln arrested legislators in Maryland so that they wouldn't convene to secede from the Union? And Virginia already had seceded, so it would have placed Washington, D.C., the nation's capital, in the middle of the rebellion. Would that have been an abuse of power for political benefit?
Well, it could be under that definition.
And you mentioned George Washington a little while ago as perhaps having met the standard of impeachment for your other panelists. In fact, let me ask you something, Professor Turley. Can you name a single president in the history of the United States, save President Harrison, who died 32 days after his inauguration, that would not have met the standard of impeachment for our friends here?
I would hope to God James Madison would escape. Otherwise, a lifetime of academic work would be shredded. Once again, I can't exclude many of these acts.
Isn't what you and I and many others are afraid of is that the standard that your friends to the right of you, and not politically, but to the right of you sitting on there, that your friends have decided that the bar is so low that when we have a Democrat president in office and a Republican House and a Republican Senate, we're going to be going through this whole scenario again in a way that really puts the country at risk.
Well, when your graphic says in your ABCs that your B is betrayal of national interest, I would simply ask, do you really want that to be your standard?
Now, isn't the difference, Professor Turley, that some people live in an ivory tower and some people live in a swamp? And those of us that are in the swamp are doing our very best for the American people,
Well,
but it's not pretty.
Actually, I live in an ivory tower in a swamp because I'm at GW, but, and it's not so bad.
I yield back.
Gentleman yields back. Ms. Bass.
Thank you very much, and I want to thank the witnesses, and I don't believe that People's House is a swamp. President Nixon was impeached for abuse of power because his conduct was, quote, undertaken for his personal political advantage and not in furtherance of any valid national policy objective. President Gerhardt, why was it significant that President Nixon acted for his personal political advantage and not in furtherance of any valid national policy objective?
It's primarily significant because in acting for his own personal benefit and not for the benefit of the country, he has crossed a line. The line here is very clear, and it becomes abuse of power when somebody's using the special authorities of their office for their own personal benefit and not the benefit of the country.
So can the same be said of President Trump?
It could be, yes. Yes.
Well, thank you. You know, I'm struck by the parallels because one of the things that Nixon did was he launched tax investigations of his political opponents. Here, the evidence shows Trump tried to launch a criminal investigation of his political opponent by a foreign government. We have heard evidence suggesting that President Trump did this for his own personal gain and not for any national policy interest. Although President Trump claims that he withheld the aid because of concerns about corruption, I do believe that we have example of the evidence of the truth.
Ambassador Sondland stated that the president only cares about big stuff. I noted there was big stuff going on in Ukraine, like a war with Russia. And Ambassador Sondland replied that he meant big stuff that benefits the president, like the Biden investigation that Mr. Giuliani was pushing.
Professor Feldman, what would the framers have thought of a president who only cares about the, quote, big stuff that benefits him?
The framers were extremely worried about a president who served only his own interests or the interests of foreign powers. That was their most serious concern when they designed the remedy of impeachment.
So the evidence also suggests that President Trump didn't even care if the investigation actually happened. What he really cared about was the public announcement of the investigation. So, Professor Carlin, how do we analyze these facts in the context of abuse of power?
Well, I think that to have a president ask for the investigation of his political opponents is an archetype of the abuse of power. And, you know, Mr. Buck mentioned past examples of this. And to say that those weren't impeachable, I think, is a big mistake. If a president wiretaps his opponents, that's a federal crime now. I don't know whether before the Wiretap Act of 1968 it was. But if a president wiretapped his opponents today, that would be impeachable conduct.
I also serve on the Foreign Affairs Committee, and I understand how significant it is to foreign leaders to meet with our presidents. To attend a meeting in the Oval Office is very significant. President Zelensky is a newly elected head of state in a fledgling democracy. His country is at war with his neighbor. Russia invaded and is occupying his country's territory. He needed the military resources to defend his country. He needed the diplomatic recognition of the American president, and he was prepared to do whatever the president demanded. Many years ago, I worked in the nation's largest trauma unit as a PA, a physician assistant. I saw people at their worst in severe pain after accidents or acts of violence. Patients I took care of were desperate and afraid and had to wait 5 to 8 hours to be seen. Can you imagine for 1 minute if I had told my patients, look, I can move you up in line and take care of your pain, but I do need a favor from you, though. My patients were in pain and they were desperate, and they would have agreed to do anything I asked. This would have been such an abuse of my position because of the power dynamic. I had the power to relieve my patients from experiencing pain. It's fundamentally wrong and in many cases illegal for us to use power to take advantage of those in crisis, especially a president, especially when lives are at stake. I yield back.
The gentlelady yields back. Mr. Ratcliffe.
Thank the chairman. Professor Turley, I'd like to start where you started because you said something that I think bears repeating. You said, I'm not a supporter of President Trump. I voted against him in 2016, and I have previously voted for Presidents Clinton and Obama. But despite your political preferences and persuasions, you reached this conclusion. The current legal case for impeachment is not just woefully inadequate, but in some respects dangerous as the basis for impeachment of an American president. So let me start by commending you for being the kind of example of what hopefully everyone on this committee will do as we approach the task that we have of determining whether or not there were any impeachable offenses here. One of the problems that you've articulated as leading you to the conclusion of calling this the, should it proceed, the shortest impeachment proceeding with the thinnest evidentiary record and the narrowest grounds ever attempted to impeach a president, is the fact that there has been this ever-changing, constantly evolving, moving target of accusations, if you will. The July 25th phone call started out as an alleged quid pro quo and briefly became an extortion scheme, a bribery scheme. I think it's back to quid pro quo. Now, besides pointing out that both Speaker Pelosi and Chairman Schiff waited until almost every witness had been deposed before they even started to use the term bribery, I think you've clearly articulated why you think the definitions that they have used publicly are flawed, if not unconstitutional, both in the 18th century or in the 21st century. But would you agree with me that bribery under any valid definition requires that a specific quid pro quo be proven?
Yes, more importantly, the Supreme Court has focused on that issue, as well as what is the definition of a quid pro quo.
So if military aid or security assistance is part of that quid pro quo, where in the July 25th transcript does President Trump ever suggest that he intends to withhold military aid for any reason?
He doesn't. And that's the reason we keep on hearing the words circumstantial and inferential. And that's what is so concerning, is that those would be appropriate terms. It's not that you can't have a circumstantial case. Those would be appropriate terms if these were unknowable facts. But the problem is that you have so many witnesses that have not been subpoenaed, so many witnesses that we have not heard from.
Right. So if it's not in the transcript, then it's got to come from witness testimony, and I assume you've reviewed all the witness testimony. So you know that no witness has testified that they either heard President Trump or were told by President Trump to withhold military aid for any reason, correct?
Correct.
So let me turn to the issue of obstruction of justice quickly. I think you assumed, as I did, that when Democrats have been talking about obstruction, it was specifically related to the Ukraine issue. And I know you've talked about that a lot today. You've clearly stated that you think that President Trump had no corrupt intent on page 39 of your report. You said something else I think that bears repeating today. You were highlighting the fact that the Democrats appear to be taking the position that if a president seeks judicial review over executive branch testimony or documents subpoenaed by Congress, that rather than letting the courts be the arbiter, Congress can simply impeach the president for obstruction based on that. Did I hear you say that if we were to proceed on that basis, that that would be an abuse of power?
I did, and let me be very clear about this. I don't disagree with my colleagues that nothing in the Constitution says you have to go to a court or wait for a court. That's not what I'm saying. What I'm saying is that if you want a well-based, a legitimate impeachment case, to set this abbreviated schedule, demand documents, and then impeach because they haven't been turned over when they go to a court, when the president goes to a court, I think that is an abuse of power. That's not what happened in Nixon. And in fact, the ultimate decision in Nixon was that there are legitimate executive privilege claims that could be raised. And some of them deal with the type of aides involved in this case, like a national security advisor, like a White House counsel. And so the concern here is not that that you can't ever impeach a president unless you go to court. It's just that you shouldn't when you have time to do it.
So if I were to summarize your testimony, no bribery, no extortion, no obstruction of justice, no abuse of power. Is that fair?
Not on this record.
The gentleman's time has expired. Mr. Richmond.
Thank you, Mr. Chairman. And let me just pick up where we left off. And I'm going to start, Mr. Turley, with your words. And it's from October 23rd, your opinion piece in the Hill. You said that, as I have said before, there is no question that the use of public office for personal gain is an impeachable offense, including the withholding of military aid in exchange for the investigation of a political opponent. You just have to prove it happened. If you can establish intent to use public office for personal gain, you have a viable, impeachable offense. We've heard today that a president abuses his power when he uses his official power for his own personal interests rather than the interests of our country. I'd like to spend more time on that because I'm really struck by one of the things that was at stake here. $400 million of taxpayer dollars. President Nixon leveraged the powers of his office to investigate political rivals. But here, the evidence shows that President Trump also leveraged taxpayer dollars to get Ukraine to announce sham investigations of President Trump's political rivals. That taxpayer money was meant to help Ukraine defend itself and in turn defend United States interests from Russian aggression. The money had been appropriated by Congress and certified by the Department of Defense. Multiple witnesses confirmed that there was unanimous support for the military aid to Ukraine. Can we listen to that, please?
From what you witnessed, did anybody in the national security community support withholding the assistance?
No. I never heard anyone advocate for holding the aid.
And the entire interagency supported the continuation of the security assistance, isn't that right?
That is correct.
I and others sat in astonishment. The Ukrainians were fighting Russians and counted on not only the training and weapons, but also the assurance of U.S. support.
Professor Feldman, you have stated that the president's demand to the president of Ukraine constituted an abuse of power. How does the president's decision to withhold military aid affect your analysis?
It means that it wasn't just an abuse of power because the president was serving his own personal interests, but also an abuse of power insofar as the president was putting American national security interests behind his own personal interests. So it brought together two important aspects of the abuse of power: self-gain and undercutting our national security interests.
The evidence points to President Trump using military aid for his personal benefit, not for the benefit of any official U.S. policy. Professor Carlin, how would the framers have interpreted that?
Well, I can't speak for the framers themselves, obviously. My view is that they would say that the president's authority to use foreign aid, and they probably couldn't have imagined we even were giving foreign aid because we were a tiny, poor country then. So it's a little hard to translate that. But what they would have said is a president who doesn't think first about the security of the United States is not doing what his oath requires him to do, which was faithfully execute the laws, hear a law appropriating money, and defend the Constitution of the United States.
Thank you. And let's go back to a segment of Mr. Turley's quote, that if you can establish intent to use public office for personal gain, you have a viable, impeachable offense. Mr. Feldman, do we meet that criteria here?
In my view, the evidence does meet that criteria, and that's the judgment that you should be making.
Ms. Carlin?
Yes, and one question I would just have for the minority members of the committee is if you were convinced that the president held up the aid because he thought it would help his reelection, would you vote to impeach him? Because I think that's really the question that everyone on this committee should be asking. And if they conclude yes, then they should vote to impeach.
Mr. Gerhardt?
Yes, I agree. And one thing I would add is that much talk has been made here about the term bribery and court decisions that, with respect to bribery. It's your job, it's the House's job to define bribery, not the courts. You follow your judgment on that.
I want to thank the witnesses, all of the witnesses, for coming and testifying today. This is not an easy decision, it's not a comfortable decision, but it's one that's necessary. We all take an oath to protect the Constitution. Our military men and women go and put their lives on the line for the Constitution, and we have an obligation to follow the Constitution, whether it's convenient or easy. Thank you, and I yield back the balance.
Gentleman yields back. Ms. Roby?
Very quickly, Professor Turley, would you like to respond?
Yes, I would. First of all, what was said in that column is exactly what I've said in my testimony. The problem is not that abuse of power can never be an impeachable offense. You just have to prove it, and you haven't. It's not enough to say, I infer this was the purpose. I infer that this is what was intended, when you're not actually subpoenaing people with direct knowledge. And instead you're saying we must vote in this rocket docket of an impeachment.
So this leads to my statement that I'd like to make. Of course, the United States House of Representatives has initiated impeachment inquiries against the President of the United States only 3 times in our nation's history prior to this one. Those impeachment inquiries were done in this committee, the Judiciary Committee, which has jurisdiction over impeachment matters. Here, in 2019, under this inquiry, fact witnesses that have been called were in front of the Intelligence Committee. We have been given no indication that this committee will conduct substantive hearings with fact witnesses. As a member serving on the Judiciary Committee, I can say that the process in which we are participating is insufficient, unprecedented, and grossly inadequate. Sitting before us is a panel of witnesses containing 4 distinguished law professors from some of our country's finest educational institutions. I do not doubt that each of you are extremely well-versed in the subject of constitutional law. And yes, there is precedent for similar panels in the aforementioned history, but only after specific charges have been made known and the underlying facts presented in full due to an exhaustive investigation. However, I don't understand why we are holding this hearing at this time with these witnesses. My colleagues on the other side of the aisle have admitted they don't know what articles of impeachment they will consider. How does anyone expect a panel of law professors to weigh in on the legal grounds for impeachment charges prior to even knowing what the charges brought by this committee are going to be? Some of my Democrat colleagues have stated over and over that impeachment should be a nonpartisan process, and I agree. One of my colleagues in the Democratic Party stated, and I quote, "Impeachment is so divisive to the country that unless there is something so compelling and overwhelming and bipartisan, I don't think we should go down that path because it divides the country." My Democratic colleagues have stated numerous times that they are on a truth-seeking and fact-finding mission. Another one of my Democratic colleagues said, and I quote, "We have a responsibility to consider the facts that emerge squarely and with the best interest of our country, not our party in our hearts." These type of historic proceedings, regardless of political beliefs, ought to be about fact-finding and truth-seeking, but that is not what this has turned out to be. Again, no disrespect to these witnesses, but for all I know, this is the only hearing that we will have, and none of them are fact witnesses. My colleagues are saying one thing and doing something completely different. No member of Congress can look their constituents in the eye and say this is a comprehensive, fact-finding, truth-seeking mission. Ranking Member Collins and members of the minority on this committee have written 6 letters over the past month to Chairman Nadler asking for procedural fairness, for all the underlying evidence to be transmitted to the Judiciary Committee, to expand the number of witnesses and have an even more bipartisan panel here today, and for clarity on today's impeachment proceedings since we haven't received evidence to review. The minority has yet to receive a response to these letters. Right here today is another very clear example for all Americans to truly understand the ongoing lack of transparency and openness with these proceedings. The witness list for this hearing was not released until late Monday afternoon. Opening statements from the witnesses today were not distributed until late last night, and the Intelligence Committee's finalized report has yet to be presented to this committee. You hear from those in the majority that process is a Republican talking point, when in reality it is an American talking point. Process is essential to the institution. A thoughtful, meaningful process of this magnitude with such great implications should be demanded by the American people. With that, I yield back.
Gentlelady yields back. Mr. Jeffries.
I did not serve in the military, but my 81-year-old father did. He was an Air Force veteran stationed in Germany during the height of the Cold War in the late 1950s. He was a teenager from inner city Newark, a stranger in a foreign land, serving on the western side of the Berlin Wall. My dad proudly wore the uniform because he swore an oath to the Constitution and believed in American democracy. I believe in American democracy. We remain the last best hope on earth. It is in that spirit that we proceed today. Professor Carlin, in America, we believe in free and fair elections. Is that correct?
Yes, it is.
But authoritarian regimes do not. Is that right?
That's correct.
Thomas Jefferson once wrote, or John Adams once wrote to Thomas Jefferson on December 6, 1787, and stated, "You are apprehensive of foreign interference, intrigue, influence. So am I. But as often as elections happen, the danger of foreign influence recurs." Professor Carlin, how important was the concept of free and fair elections to the framers of the Constitution?
Honestly, it was less important to them than it's become in our Constitution since then. And if you'll remember, one of the things that turned me into a lawyer was seeing Barbara Jordan, who was the first female lawyer I'd ever seen in practice, say on the committee that we, the people, didn't include people like her in 1789, but through a process of amendment, we have done that. And so elections are more important to us today as a constitutional matter than they were even to the framers.
And is it fair to say that an election cannot be reasonably characterized as free and fair if it's manipulated by foreign interference?
That's correct.
And the framers of the Constitution were generally and deeply concerned with the threat of foreign interference in the domestic affairs of the United States, true?
Yes.
And why were they so deeply concerned?
Because foreign nations don't have our interests at heart. They have their interests at heart.
And would the framers find it acceptable for an American president to pressure a foreign government to help him win an election?
I think they'd find it unacceptable for a president to ask a foreign government to help him, whether they put pressure on him or not.
Direct evidence shows that on a July 25th phone call, the president uttered 5 words: "Do us a favor, though." He pressured the Ukrainian government to target an American citizen for political gain, and at the same time, simultaneously withheld $391 million in military aid. Now, Ambassador Bill Taylor, West Point graduate, Vietnam War hero, Republican-appointed diplomat, discussed this issue of military aid. Here is a clip of his testimony.
Again, our holding up of security assistance that would go to a country that is fighting aggression from Russia for no good policy reason, no good substantive reason, no good national security reason is wrong.
To the extent the military aid was being withheld as part of an effort to solicit foreign interference in the 2020 election, is that behavior impeachable?
Yes, it is, and if I could go back to one of the words you read, when the president said, do us a favor, he was using the royal we there. It wasn't a favor for the United States. He should have said, do me a favor, because only kings say us when they mean me.
And is it correct that an abuse of power that strikes at the heart of our democracy falls squarely within the definition of a high crime and misdemeanor?
Yes, it does.
Some of my colleagues have suggested that impeachment would overturn the will of the people. The American people expressed their will in November of 2018. The will of the people elected a new majority. The will of the people elected a House that would not function as a wholly owned subsidiary of this administration. The will of the people elected a House that understands we are a separate and co-equal branch of government. The will of the people elected a House that understands we have a constitutional responsibility to serve as a check and balance on an out-of-control executive branch. The president abused his power and must be held accountable. No one is above the law. America must remain the last best hope on earth. I yield back.
Gentleman yields back. Mr. Gates.
The will of the American people also elected Donald Trump to be the president of the United States in the 2016 election, and there's one party that can't seem to get over it. Now, we understand the fact that in 2018 you took the House of Representatives, and we haven't spent our time during your tenure in power trying to remove the Speaker of the House, trying to delegitimize your ability to govern. Frankly, we'd love to govern with you. We'd love to pass USMCA. We'd love to put out a helping hand to our seniors and lower prescription drug prices. It's the will of the people you ignore when you continue down this terrible road of impeachment. Professor Gerhardt, you gave money to Barack Obama, right?
My family did, yes.
4 times?
That sounds about right. Yes.
Mr. Chairman, I have a series of unanimous consent requests relating to Professor Feldman's work. The first, Noah Feldman, Trump's wiretap tweets raise risk of impeachment.
Gentleman will suspend.
My time.
We'll take that time off. Has the gentleman submitted? Have we seen those that material?
We can provide it to you, as is typical for unanimous.
And we'll consider the unanimous consent request later after we review
Very
the
well.
material.
Very well. Thank you.
The gentleman may continue.
Thank you, Mr. Chairman. Mr. Feldman wrote articles entitled, "Trump's Wiretap Tweets Raise Risk of Impeachment." He then wrote, "Mar-a-Lago ad belongs in impeachment file." And then Mr. Jake Flanagan wrote in Quartz, "A Harvard law professor thinks Trump could be impeached over fake news accusations." My question, Professor Feldman, is since you seem to believe that the basis for impeachment is even broader than the basis that my Democrat colleagues have laid forward, do you believe you're outside of the political mainstream on the question of impeachment?
I believe that impeachment is warranted whenever the president abuses his power for personal benefit or to corrupt the democratic process.
Did you write an article entitled, "It's Hard to Take Impeachment Seriously Now"?
Yes, I did write that article.
And in that article, did you write, hold on, I'm limited on time, sir.
I wrote
Did you
that
write,
article.
since the
Would you like me to answer the
2018
question,
midterm
sir?
election, House Democrats have made it painfully clear that discussing impeachment is primarily or even exclusively a tool to weaken President Trump's chances in 2020. Did you write those words?
Until this call on July 25th, I was an impeachment skeptic. The
Very
call
well.
changed my mind, sir, and for
Thank
good
you. I
reason.
appreciate your testimony. Professor Carlin, you gave $2,000, or you gave $1,000 to Elizabeth Warren, right?
I believe so.
You gave $1,200 to Barack Obama,
I have no reason to question that.
and you gave $2,000 to Hillary Clinton.
That's correct.
Why so much more for Hillary than the other two?
Because I've been giving a lot of money to charity recently because of all of the poor people in the United States.
Well, those aren't the only folks you've been given to. Now, have you ever been on a podcast called Versus Trump?
I think I was on a live panel that the people who ran the podcast called Versus Trump.
On that, do you remember saying the following? Liberals tend to cluster more. Conservatives, especially very conservative people, tend to spread out more, perhaps because they don't even want to be around themselves. Did you say that?
Yes, I did.
Do you understand how that reflects contempt on people who are conservative?
No, what I was talking about there was the natural tendency, if you put the quote in context, the natural tendency of a compactness requirement to favor a party whose voters are more spread out.
Well,
and I do
Professor,
not have contempt
hold on.
for
Again,
conservatives.
I'm
and I
very
do not have
limited on
contempt
time,
for
Professor. And so I just have to say, when you talk about how liberals want to be around each other and cluster, and conservatives don't want to be around each other, and so they have to spread out, it makes people, you may not see this from, like the ivory towers of your law school, but it makes actual people in this country
When
feel
the
like,
president
excuse
calls
me, you don't get to interrupt me on this time. Now, let me also suggest that when you invoke the president's son's name here, when you try to make a little joke out of referencing Barron Trump, that does not lend credibility to your argument. It makes you look mean. It makes you look like you're attacking someone's family, the minor child of the President of the United States. So let's see if we can get into the facts. To all of the witnesses, if you have personal knowledge of a single material fact in the Schiff report, please raise your hand. And let the record reflect. No personal knowledge of a single fact. And you know what? That continues on the tradition that we saw from Adam Schiff, where Ambassador Taylor could not identify an impeachable offense. Mr. Kent never met with the president. Fiona Hill never heard the president reference anything regarding military aid. Mr. Hale was unaware of any nefarious activity with aid. Colonel Vindman even rejected the new Democrat talking point that bribery was invoked here. Ambassador Volker denied that there was a quid pro quo, and Mr. Morrison said there was nothing wrong on the call. The only direct evidence came from Gordon Sondland, who spoke to the President of the United States, and the President said, "I want nothing, no quid pro quo." And you know what? If wiretapping a political opponent's an impeachable offense, I look forward to reading that Inspector General's report, because maybe it's a different president we should be impeaching.
Gentleman's time has expired, Mr. Cicilline.
Thank you, Mr. Chairman. Professor Feldman, let me begin by stating the obvious. It is not hearsay when the president tells the president of Ukraine to investigate his political adversary, is it?
It is not.
It is not hearsay when the president then confesses on national television to doing that, is it?
It is not.
It is not hearsay when administration officials testify that they hear the president say he only cares about the investigations of his political opponent. Is it?
No, that is not hearsay.
And there's lots of other direct evidence in this 300-page report from the Intelligence Committee, so let's dispense with that claim by my Republican colleagues. Professor Garrity, Professor Turley, notwithstanding what he said today, wrote on August 1st, 2014, in a piece called 5 Myths About Impeachment. One of the myths he was rejecting was that impeachment required a criminal offense. And he wrote, and I quote, "An offense does not have to be indictable. Serious misconduct or a violation of public trust is enough," end quote. Was Professor Turley right when he wrote that back in 2014?
Yes, I agree with that.
Okay. Now, next I'm going to move to Professor Carlin. At the Constitutional Convention, Elbridge Gerry said, and I quote, "Foreign powers will intermeddle in our affairs and spare no expense to influence them." And in response, James Madison said that impeachment was needed because otherwise a president, and I quote, "might betray his trust to a foreign power." Professor Carlin, can you elaborate on why the framers were so concerned about foreign interference, how they accounted for these concerns, and how that relates to the facts before this committee?
So the reason that the framers were concerned about foreign interference, I think, is slightly different than the reason we are. They were concerned about it because we were such a weak country in 1789. We were small, we were poor, we didn't have an established navy, we didn't have an established army. Today, the concern is a little different, which is that it will interfere with us making the decisions that are best for us as Americans.
Thank you, Professor. There are 3 known instances of the president publicly asking a foreign country to interfere in our elections. First, in 2016, the president publicly hoped that Russia would hack into the email of a political opponent, which they subsequently did. Second, based on the president's own summary of his call with Ukrainian President Zelensky, we know he asked Ukraine to announce an investigation of his chief political rival and used aid appropriated by Congress as leverage in his efforts to achieve this. And third, the president then publicly urged China to begin its own investigation. Professor Feldman, how would it impact our democracy if it became standard practice for the President of the United States to ask a foreign government to interfere in our elections?
It would be a disaster for the functioning of our democracy if our presidents regularly, as this president has done, asked foreign governments to interfere in our electoral process.
I'd like to end with a powerful warning from George Washington, who told Americans in his farewell address, and I quote, "to be constantly awake, since history and experience prove that foreign influence is one of the most baneful foes of Republican government," end quote. The conduct at issue here is egregious and warrants a commensurate response. The president has openly and repeatedly solicited foreign interference in our elections. Of that, there is no doubt. This matters because inviting foreign meddling into our elections robs the American people of their sacred right to elect their own political leaders. Americans all across this country wait in long lines to exercise their right to vote and to choose their own leaders. This right does not belong to foreign governments. We fought and won a revolution over this. Free and fair elections are what separate us from authoritarians all over the world. As public servants and members of the House, we would be negligent in our duties under the Constitution if we let this blatant abuse of power go unchecked. We've heard a lot about hating this president. It's not about hating this president. It's about our love of country. It's about honoring the oath that we took to protect and defend the Constitution of this great country. And so my final question is to Professor Feldman and to Professor Carlin. In the face of this evidence, what are the consequences if this committee and this Congress refuses to muster the courage to respond to this gross abuse of power that undermine the national security of the United States, that undermine the integrity of our elections, and that undermined the confidence that we have to have in the president to not abuse the power of his office?
If this committee and this House fail to act, then you're sending a message to this president and to future presidents that it's no longer a problem if they abuse their power, it's no longer a problem if they invite other countries to interfere in our elections, and it's no longer a problem if they put the interests of other countries ahead of ours.
Professor Carlin?
I agree with Professor Feldman, and I should say just one thing, and I apologize for getting a little overheated a moment ago, but I have a constitutional right under the First Amendment to give money to candidates. At the same time, we have a constitutional duty to keep foreigners from spending money in our elections, and those two things are two sides of the same coin.
Thank you, and with that, I yield back, Mr. Chairman.
Gentleman yields back. Mr. Johnson.
Thank you. I was struck this morning by the same thing as all my friends and colleagues on this side of the room. Chairman Nadler actually began this morning with the outrageous statement that the facts before us are undisputed. Of course, everyone here knows that that's simply not true. Every person here, every person watching at home knows full well that virtually everything here is disputed, from the fraudulent process and the broken procedure to the Democrats' unfounded claims. And the full facts are obviously not before us today. We've been allowed no fact witnesses here at all. For the first time ever, this committee, which is the one in Congress that has the actual jurisdiction over impeachment, is being given no access to the underlying evidence that Adam Schiff and his political accomplices claim supports this whole charade. This is just a shocking denial of due process. And I want to say to our witnesses, I'm also a constitutional law attorney, and under normal circumstances, I really would greatly enjoy an academic discussion with you, a debate about the contours of Article 2, Section 4. But that would be an utter waste of our time today, because as has been highlighted so many times this morning, this whole production is a sham and a reckless path to a predetermined political outcome. And I want you to know it's an outcome that was predetermined by our Democrat colleagues a long time ago. The truth is, House Democrats have been working to impeach President Donald J. Trump since the day he took his oath of office. Over the past 3 years, they've introduced 4 different resolutions seeking to impeach the president. Almost exactly 2 years ago, as one of the graphics up here shows, December 6, 2017, 58 House Democrats voted to begin impeachment proceedings. Of course, that was almost 20 months before the famous July 25th phone call with Ukraine's President Zelensky. And this other graphic up here is smaller, but it's interesting too. I think it's important to reiterate for everybody watching at home that of our 24 Democrat colleagues and friends on the other side of the room today, 17 out of 24 have already voted for impeachment. So, I mean, let's be honest. Let's not pretend that anybody cares anything about what's being said here today or the actual evidence or the facts. As Congresswoman Lofgren said, we come with open minds. That's not happening here. So much for an impartial jury. Several times this year, leading Democrats have frankly admitted in various interviews and correspondence that they really believe this entire strategy is necessary because, why? Because they want to stop the president's reelection. Even Speaker Pelosi said famously last month that, quote, "it is dangerous to allow the American people to evaluate his performance at the ballot box. Speaker Pelosi has it exactly backwards. What is dangerous here is the precedent all this is setting for the future of our republic. I love what Professor Turley testified to this morning. He said, this is simply not how the impeachment of a president is done. His rhetorical question to all of our colleagues on the other side is still echoing throughout this chamber. He asked you to ask yourselves, where will this and where will you stand next time when this same kind of sham impeachment process is initiated against a president from your party? The real shame here today is that everything in Washington has become bitterly partisan, and this ugly chapter is not going to help that. It's going to make things really that much worse. President Turley said earlier that we are now living in the era that was feared by our founders, what Hamilton referred to as a period of agitated passions. I think that says it so well. This has indeed become an age of rage. President Washington warned in his farewell address in 1796 that extreme partisanship would lead us to the ruins of public liberty. Those were his words. This hyper-partisan impeachment is probably one of the most divisive and destructive things that we could possibly do to our American family. Let me tell you what I heard from my constituents in multiple town halls and meetings back in my district just 2 days ago. The people of this country are sick of this. They're sick of the politics of personal destruction. They're sick of this toxic atmosphere that is being created here, and they're deeply concerned about where all this will lead us in the years ahead, rightfully so. You know what the greatest threat is? The thing that ought to keep every single one of us up at night is the rapidly eroding trust of the American people in their institutions. One of the critical presuppositions and foundations of a self-governing people in a constitutional republic is that they will maintain a basic level of trust in their institutions, in the rule of law, in the system of justice, in the body of elected representatives, their citizen legislators in the Congress. The greatest danger of this fraudulent impeachment production is not what happens this afternoon or by Christmas or in the election next fall. The greatest danger is what this will do in the days ahead to our 243-year experiment in self-governance. What effect this foolish new precedent, this Pandora's box, will have upon our beleaguered nation 6 or 7 years from now, a decade from now, in the ruins of public liberty that are being created by this terribly short-sighted exercise today. God help us. I yield back.
The gentleman yields back. Mr. Swalwell.
Professor Turley, as a former prosecutor, I recognize a defense attorney trying to represent their client, especially one who has very little to work with in the way of facts. And today, you're representing the Republicans in their defense of the president. Professor,
that's not my intention, sir.
You've said that this case represents a dramatic turning point in federal impeachment precedent, the impact of which will shape and determine future cases. The House, for the first time in the modern era, asked the Senate to remove someone for conduct for which he was never charged criminally and the impropriety of which has never been tested in a court of law. But that's actually not a direct quote from what you said today. It sounds a lot like what you've argued today, but that's a quote from what you argued as a defense lawyer in a 2010 Senate impeachment trial. Professor, did you represent federal Judge Thomas Porteous?
I did indeed.
And Judge Porteous was tried on 4 articles of impeachment, ranging from engaging in a pattern of conduct that is incompatible with the trust and confidence placed in him as a federal judge, to engaging in a long-standing pattern of corrupt conduct that demonstrates his unfitness to serve as a United States District Court judge. On each count, Judge Porteous was convicted by at least 68 and up to 96 bipartisan senators. Thankfully, that Senate did not buy your argument that a federal official should not be removed if he is not charged criminally. And respectfully, Professor, we don't buy it either. But we're here because of this photo. It's a picture of President Zelensky in May of this year, standing on the eastern front of Ukraine as a hot war was taking place and up to 15,000 Ukrainians have died at the hands of Russians. I'd like to focus on the impact of President Trump's conduct, particularly with our allies and our standing in the world. This isn't just a president, as Professor Carlin has pointed out, asking for another foreign leader to investigate a political opponent. It also is a president leveraging a White House visit as well as foreign aid. As the witnesses have testified, Ukraine needs our support to defend itself against Russia. I heard directly from witnesses how important the visit and the aid were, particularly from Ambassador Taylor.
These weapons and this assistance It allows the Ukrainian military to deter further incursions by the Russians against Ukrainian territory. If that further incursion, further aggression were to take place, more Ukrainians would die.
Professor Carlin, does the president's decision to withhold from Ukraine such important official acts, a White House visit and military aid, in order to pressure President Zelensky relate to the framers' concerns about abuse of power and entanglements with foreign nations?
It relates to the abuse of power. The entanglement with foreign nations is a more complicated concept for the framers than for us.
Professor Carlin, I think you'd agree we are a nation of immigrants.
Yes.
Today, 50 million immigrants live in the United States. I'm moved by one who recently told me as I was checking into a hotel about his Romanian family. He came here from Romania and said that every time he had gone home for the last 20 years, he would always tell his family members how corrupt his country was, that he had left and why he had come to the United States. And he told me in such humiliating fashion that when he has gone home recently, they now wag their finger at him and say, "You're going to lecture us about corruption?" What do you think, Professor Carlin, does the president's conduct say to the millions of Americans who left their families and livelihoods to come to a country that represents the rule of law?
I think it suggests that we don't believe in the rule of law, and I think it tells emerging democracies around the world not to take it seriously when we tell them that their elections are not legitimate because of foreign interference, or their elections are not legitimate because of persecution of the opposing party. I mean, President Bush announced that he did not consider the elections in Belarus in 2006 to be legitimate for exactly that reason, because they went after political opponents.
Thank you. Finally, Professor Feldman, Professor Turley has pointed out that we should wait and that we should go to the courts, but you would acknowledge that we've gone to the courts. We've been in the courts for over 6 months, many times on matters that are already settled in the United States Supreme Court, particularly U.S. v. Nixon, where the president seems to be running out the clock. Is that right?
Yes, sir.
Thank you, and I yield back.
Gentleman yields back. In a moment, we will recess for a brief 5 minutes. First, I ask everyone in the room to please remain seated and quiet while the witnesses exit the room. I also want to remind those in the audience that you may not be guaranteed your seat if you leave the hearing room at this time. At this time, the committee will stand in a short recess.
I now recognize myself to give an opening statement in the impeachment inquiry into Donald J. Trump, the 45th President of the United States. This morning we will hear from Gordon Sondland, the American Ambassador to the European Union. We are here today as part of the House of Representatives impeachment inquiry.
So we're here for the arrival. Once they're seated and we get a look from the chairman, you'll start to hear voices saying, everybody get back. TV will go to the side. Everybody stays in the room for the swearing in. And then after the swearing in, I'll start to tap, or my colleague will start to tap you on the shoulder, and all TV will go out, and then we'll start to rotate from that line over there.
Ambassador Sondland was a skilled deal maker, but in trying to satisfy a directive from the president, found himself increasingly embroiled in an effort to press the new Ukrainian president that deviated sharply from the norm in both terms of policy and process.
Story time last night. We get story time first thing this morning. Ambassador Sondland, welcome. Glad you're here. I'm really not glad you're here, but welcome to the 5th day of this circus.
If you would please rise and raise your right hand, I will begin by swearing you in. Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God? Let the record show the witness has answered in the affirmative. Thank you, and please be seated. Please speak directly into it. Your written statement will remain a part of the record. With that, Ambassador Sondland, you are now recognized for the opening statement. Thank you, Mr. Chairman.
The call lasted 5 minutes. I remember I was at a restaurant in Kiev, and I have no reason to doubt that this conversation included the subject of investigation. It's true that the president speaks loudly at times, and it's also true, I think we primarily discussed ASAP Rocky. It's true that the president likes to use colorful language. Anyone who has met with him at any reasonable amount of time knows them.
The best direct evidence we have is actually what the president told you. I want nothing. There is no quid pro quo.
Who would benefit from an investigation of the Bidens?
I assume President Trump would benefit.
There we have it, see? Didn't hurt a bit, did it?
Getting caught is no defense, not to a violation of the Constitution, and it certainly doesn't give us a reason to ignore our own oath of office. We are adjourned. I now recognize myself to give an opening statement in the impeachment inquiry into Donald J. Trump, the 45th President of the United States. This morning we will hear from Gordon Sondland, the American Ambassador to the European Union. We are here today as part of the House of Representatives impeachment inquiry.
So we're here for the arrival. Once they're seated and we get a look from the chairman, you'll start to hear voices saying, everybody get back. TV will go to the side. Everybody stays in the room for the swearing in. And then after the swearing in, I'll start to tap, or my colleague will start to tap you on the shoulder, and all TV will go out, and then we'll start to rotate from that line over there.
Committee will come to order. We have
Ambassador Sondland was a skilled deal maker.
Thank you. One of my colleagues wondered how this panel can opine as to whether the president committed an impeachable offense. And the answer, quite frankly, is because you came in with a preconceived notion. You already made that determination decision. And I'll give you for instance. Until a recent colloquy, several of you consistently said that the president said, during that July 25th conversation with President Zelensky, you said, the president said, I would like you to do me a favor. But that is inaccurate. It was finally cleared in that colloquy, and I'm going to read it to you. I would like you to do us a favor, though, because our country has been through a lot. One of you said, well, that's because the president was using royal we. Here the president's talking about the country. That's what he's talking about. It's audacious to say it's using the royal we. That's royal, all right, but it ain't the royal we. And I'll just tell you, when you come in with a preconceived notion, it becomes obvious. One of you just said, Mr. Feldman, it was you who said, and I'm going to quote here, roughly, I think this is exactly what you said, though. Until the call of July 25th, I was an impeachment skeptic, too. I don't know, I'm looking at an August 23rd, 2017 publication where you said, if President Donald Trump pardons Joe Arpaio, it would be an impeachable offense. He did ultimately pardon him. In 2017, the New York Review of Books, Mr. Feldman, Professor Feldman said, defamation by tweet is an impeachable offense. And I think of the history of this country, and I think if defamation or libel or slander is an impeachable offense, I can't help but reflect about John Adams, about Thomas Jefferson, who routinely pilloried their political opponents. In fact, at the time, the factions or parties actually bought newspapers to attack their political opponents. So this rather expansive and generous view you have on what constitutes impeachment is a real problem. This morning, one of you mentioned the Constitutional Convention, and several of you mentioned Mr. Davies, and you talked about the Constitutional Convention. It's been a while since I read the minutes, so I just briefly reviewed, because I remembered the discussion on the impeachment as being more pervasive, a little bit more expanded. And on July 20th, 1787, it wasn't 1789, by the way, one of you testified it was 1789. It was in 1787, July 20th, Benjamin Franklin is discussing impeachment of a Dutch leader. And he talks specifically about what he would anticipate an impeachment to look like. He said it would be a regular and peaceable inquiry that would have taken place, and if guilty, then there'd be a punishment. If acquitted, then the innocent would be restored to the confidence of the public. That needs to be taken into account as well. So I look also on a May 17, 2017 BBC article, which is a discussion about impeachment because President Trump had fired James Comey. Alex Whiting of Harvard said, it was hard to make the obstruction of justice case with this sacking alone. The president had clear legal authority, and there was arguably proper or at least other reasons put forward for firing him. And yet, what we have here is this insistence by Ms. Gerhardt that that was impeachable. That's contained in that article. Refer you to it, May 17, 2017, BBC. What I'm suggesting to you today is a reckless bias coming in here. You're not fact witnesses. You're supposed to be talking about what the law is, but you came in with a preconceived notion and bias. And I want to read one last thing here, if I can find it, from one of our witnesses here. And it's dealing with something that was said in a Maryland Law Review article in 1999. And basically, if I can get to it, he's talking about this, where he's being critical of lack of self-doubt and an overwhelming arrogance on the part of law professors who come in and opine on impeachment. That would be you, Mr. Gerhardt, who said something like that. I can't find my quote or else I'd give it to you. And so what I'm telling you is that is what has been on display in this committee today. And with that, I yield back.
The gentleman yields back. A little while ago, Mr. Gates asked that certain Material be inserted into the record by unanimous consent. I ask for an opportunity to review it. We have reviewed it. The material will be inserted without objection. Mr. Liu.
Thank you, Chairman Nadler. I first swore an oath to the Constitution when I was commissioned as an officer in the United States Air Force. And the oath I took was not to a political party or to a president or to a king. It was an oath to a document that has made America the greatest nation on earth. I never imagined we'd now be in a situation where the president or commander-in-chief is accused of using his office for personal political gain that betrayed U.S. national security, hurt our ally Ukraine, and helped our adversary Russia. Now, the Constitution provides a safeguard for when the president's abuse of power and betrayal of national interests are so extreme that it warrants impeachment and removal. It seems notable that of all the offenses they could have included and enumerated in the Constitution, bribery is one of only 2 that are listed. So, Professor Feldman, why would the framers choose bribery of all the possible offenses they could have included to list?
Bribery was the classic example for them of the high crime and misdemeanor of abuse of office for personal gain. Because if you take something of value when you're able to affect an outcome for somebody else, you're serving your own interests and not the interests of the people. And that was commonly used in impeachment offenses in England, and that's one of the reasons that they specified it.
Thank you. Now, earlier in this hearing, Professor Carlin made the point that bribery as envisioned by the framers was much broader than the narrow federal criminal statute of bribery. I think the reason for that is obvious. We are not in a criminal proceeding. We're not deciding whether to send President Trump to prison. This is a civil action. It's an impeachment proceeding to decide whether or not we remove Donald Trump from his job. And so, Professor Carlin, it's true, isn't it, that we don't have to meet the standards of a federal bribery statute in order to meet the standards for an impeachable offense?
That's correct. I'm sorry, that's correct.
Thank you. Yesterday, Scalia law professor J.W. Verrett, who was a lifelong Republican, former Republican Hill staffer, and who advised the Trump pre-transition team, made the following public statement about Donald Trump's conduct. The call wasn't perfect. He committed impeachable offenses, including bribery. So, Professor Carlin, I'm now going to show you 2 video clips of the witness testimony relating to the president's withholding of the White House meeting in exchange for the public announcement of the investigation into his political rival.
As I testified previously, Mr. Giuliani's requests were a quid pro quo for arranging a White House visit for President Zelensky.
By mid-July, it was becoming clear to me that the meeting President Zelensky wanted was conditioned on the investigations of Burisma and alleged Ukrainian interference in the 2016 U.S. elections.
And then I'm going to show you one more video clip relating to the president's decision to withhold security assistance that Congress had appropriated to Ukraine in exchange for announcement of public investigation of his political rival.
In the absence of any credible explanation for the suspension of aid, I later came to believe that the resumption of security aid would not occur until there was a public statement from Ukraine committing to the investigations of the 2016 elections and Burisma, as Mr. Giuliani had demanded.
Professor Carlin, does that evidence, as well as the evidence in the record, tend to show that the president met the standards for bribery as envisioned in the Constitution?
Yes, it does.
I'm also a former prosecutor. I believe the record and that evidence would also meet the standards for criminal bribery. The Supreme Court's decision in McDonough was primarily about what constitutes an official act. The key finding was an official act must involve a formal exercise of governmental power on something specific pending before a public official. Pretty clear we got that here. We have hundreds of millions of dollars of military aid that Congress specifically appropriated. The freezing and unfreezing of that aid is a formal exercise of governmental power. But we don't even have to talk about the crime of bribery. There's another crime here, which is the solicitation of federal of assistance of a foreign government in a federal election campaign. That straight up violates the Federal Election Campaign Act at 52 U.S.C. 3101. And oh, by the way, that act is also one reason Michael Cohen is sitting in prison right now. I yield back.
The gentleman yields back. Mr. McClintock.
Thank you, Mr. Chairman. Could I begin just with a show of hands? How many on the panel actually voted for Donald Trump in 2016?
I don't think
show
we're
of
obligated
hands.
to say anything about how we cast our ballots.
Just show of hands.
I will not.
I think you've made your positions, Professor Carlin, very, very
Gentlemen,
clear.
the gentleman will suspend, and we'll suspend the clock too.
I have a right to cast a
excuse me, you may ask the
ballot.
question.
All right, well, let me
You
rephrase
may
the
a-
question. How
excuse me.
many of you
The clock is
supported?
stopped for the moment. The gentleman may ask the question. The witnesses don't have to respond.
How many of
the
you
gentleman's time is
supported
restored.
Donald Trump in 2016? Show of hands.
Not raising our hands is not an
Professor-
indication of an answer, sir.
Professor Turley, this impeachment inquiry has been predicated on some rather disturbing legal doctrines. One Democrat asserted that hearsay can be much better evidence than direct evidence. Speaker Pelosi and others have said that the president's responsibility is to present evidence to prove his innocence. Chairman Schiff's asserted, and we heard a discussion from some of your colleagues today, that if you invoke legal rights in defense of criminal accusations, ipso facto, that's an obstruction of justice and evidence of guilt. My question of you is, what does it mean to our American justice system if these doctrines take root in our country?
Well, what concerns me the most is that there are no limiting principles that I can see in some of the definitions that my colleagues have put forward. And more importantly, some of these impeachable offenses I've only heard about today. I'm not too sure what attempting to abuse office means or how you recognize it. But I'm pretty confident that nobody on this committee truly wants the new standard of impeachment to be betrayal of the national interest, that is going to be the basis for impeachment.
Well,
how many Republicans do you think would say that Barack Obama violated that standard? That's exactly what James Madison warned you against, is that you would create effectively a vote of no confidence standard in our Constitution.
Well, then are we in danger of abusing our own power, of doing enormous violence to our Constitution by proceeding in this manner? My Democratic colleagues have been searching for a pretext for impeachment since before the president was sworn in. On this panel, Professor Carlin called President Trump's election illegitimate in 2017. She implied impeachment was a remedy. Professor Feldman advocated impeaching the president over a tweet that he made in March of 2017. That's just 7 weeks after his inauguration. Are we in danger of succumbing to the maxim of Lewis Carroll's Red Queen? Sentence first, verdict afterwards?
Well, this is part of the problem of how your view of the president can affect your assumptions, your inferences, your view of circumstantial evidence. I'm not suggesting that the evidence, if it was fully investigated, would come out one way or the other. What I'm saying is that we are not dealing with the realm of the unknowable. You have to ask. We've burned 2 months in this House, 2 months, that you could have been in court seeking a subpoena for these witnesses. It doesn't mean you have to wait forever, but you could have gotten an order by now. You could have allowed the president to raise an executive privilege.
I need to go on here. The Constitution says that the executive authority shall be vested in a president of the United States. Does that mean some of the executive authority or all of it?
Well, obviously there's checks and balances on all of these, but the executive authority primarily obviously rests with the president, but these are all shared powers. And I don't begrudge the investigation of the Ukraine controversy. I think it was a legitimate investigation. What I begrudge is how it has been conducted.
Well, I tend to agree with that. I mean, the Constitution commands the president to take care that the laws be faithfully enforced. That does, in effect, make him the chief law enforcement officer in the federal government, does it not?
That's commonly expressed that way. Yeah.
So if probable cause exists to believe a crime's been committed, does the president have the authority to inquire into that matter?
He has, but I have to, this is where I think we would depart. I've been critical of the president in terms of crossing lines with the Justice Department. I think that has caused considerable problems. I also don't believe it's appropriate. But we often confuse what is inappropriate with what's impeachable. You know, many people feel that what the president has done is obnoxious, contemptible,
let me
but
just ask you one
contemptible is
final-
not synonymous with impeachment.
Let me ask you one final question. The National Defense Authorization Act that authorized aid to the Ukraine requires the Secretary of Defense and state to certify that the government of Ukraine has taken substantial actions to make defense institutional reforms, for, among other things, for purposes of decreasing corruption. Is the president exercising that responsibility when he inquires into a matter that could involve illegalities between American and Ukrainian officials?
Yeah, that's what I'm referring to as unexplored defenses. Part of the bias when you look at these facts is you just ignore defenses. You say, well, those are just invalid. But they're the defenses. They're the other side's account for actions, and that's what hasn't been explored.
Gentleman's time has expired. Mr. Raskin.
Thank you, Mr. Chairman. I want to thank the witnesses for their hard work on a long day. I want to thank them especially for invoking the American Revolution, which not only overthrew a king, but created the world's first anti-monarchical constitution. Your erudition makes me proud to have spent a quarter century of my career as a fellow constitutional law professor before running for Congress. Now, Tom Paine said that in the monarchies, the king is law, but in the democracies, the law will be king. But today, the president advances an essentially monarchical argument. He says that Article 2 allows him to do whatever he wants. He not only says that, but he believes it because he did something no other American president has ever done before. He used foreign military aid as a lever to coerce a foreign government to interfere in an American election to discredit an opponent and to advance his re-election campaign. Professor Carlin, what does the existence of the impeachment power tell us about the president's claim that the Constitution allows him to do whatever he wants?
It blows it out of the water.
If he's right, and we accept this radical claim that he can do whatever he wants, all future presidents seeking re-election will be able to bring foreign governments into our campaigns to target their rivals and to spread propaganda. That's astounding. If we let the president get away with this conduct, every president can get away with it. Do you agree with that, Professor Feldman?
I do. Richard Nixon sent burglars to break into the Democratic National Committee headquarters, but President Trump just made a direct phone call to the president of a foreign country and sought his intervention in an American election.
So this is a big moment for America, isn't it? If Elijah Cummings were here, he would say, listen up, people, listen up. How we respond will determine the character of our democracy for generations. Now, Professors Feldman, Carlin, and Gerhardt tell us there were three dominant reasons invoked at the founding for why we needed an impeachment power. Broadly speaking, it was an instrument of popular self-defense against a president behaving like a king and trampling the rule of law. But not just in the normal royal sense of showing cruelty and vanity and treachery and greed and avarice and so on, but when presidents threatened the basic character of our government and the Constitution. That's what impeachment was about. And the framers invoked three specific kinds of misconduct so serious and egregious that they thought they warranted impeachment. First, the president might abuse his power by corruptly using his office for personal, political, or financial gain. Well, Professor Feldman, what's so wrong with that? If the president belongs to my party and I generally like him, what's so wrong with him using his office to advance his own political ambitions?
Because the President of the United States works for the people. And so if he seeks personal gain, he's not serving the interests of the people. He's rather serving the interests that are specific to him. And that means he's abusing the office and he's doing things that he can only get away with because he's the president. And that is necessarily subject to impeachment.
Well, second and third, the founders expressed fear that a president could subvert our democracy by betraying his trust to foreign influence and interference, and also by corrupting the election process. Professor Carlin, you're one of America's leading election law scholars. What role does impeachment play in protecting the integrity of our elections, especially in an international context in which Vladimir Putin and other tyrants and despots are interfering to destabilize elections around the world?
Well, you know, Congress has enacted a series of laws to make sure that there isn't foreign influence in our elections, and allowing the president to circumvent that principle is a problem. And as I've already testified several times, America is not just the last best hope, as Mr. Jeffrey said, but it's also the shining city on a hill. And we can't be the shining city on a hill and promote democracy around the world if we're not promoting it here at home.
Now, any one of these actions alone would be sufficient to impeach the president, according to the founders, but is it fair to say that all three causes for impeachment explicitly contemplated by the founders, abuse of power, betrayal of our national security, and corruption of our elections, are present in this president's conduct? Yes or no? Professor Feldman?
Yes.
And Professor Gerhardt?
Yes, sir.
And Professor Carlin?
Yes.
You all agree, okay. And are any of you aware of any other president who has essentially triggered all three concerns that animated the founders?
No.
No.
And no as well.
Mr. Chairman, it's hard to think of a more monarchical sentiment than I can do whatever I want as president, and I yield back.
Gentleman yields back. Ms. Lesko.
Thank you, Mr. Chair. Mr. Chair, I ask unanimous consent to insert into the record a letter I wrote and sent to you calling on you to cancel any and all future impeachment hearings and outlining how the process—
Without objection, the letter will be entered into the record.
Thank you. During an interview, Mr. Chairman, on MSNBC's Morning Joe, on November 26, 2018, Chairman Nadler outlined a three-pronged test that he said would allow for a legitimate impeachment proceeding. Now, I quote Chairman Nadler's remarks. And this is what he said. There really are three questions, I think. First, has the president committed impeachable offenses? Second, do those offenses rise to the gravity that's worth putting the country through the drama of impeachment? And number three, because you don't want to tear the country apart, you don't want half of the country to say to the other half for the next 30 years, we won the election, you stole it from us. You have to be able to think at the beginning of the impeachment process that the evidence is so clear, of offenses so grave, that once you've laid out all of the evidence, a good fraction of the opposition, the voters, will reluctantly admit to themselves they had to do it. Otherwise, you have a partisan impeachment which will tear the country apart. If you meet these three tests, then I think you do the impeachment. And those were the words of Chairman Nadler. Now, let's see if Chairman Nadler's three-pronged test has been met. First, has the president committed an impeachable offense? No. The evidence and testimony has not revealed any impeachable offense. Second, do those offenses rise to the gravity that's worth putting the country through the drama of impeachment? Again, the answer is no. There is nothing here that rises to the gravity that's worth putting the country through the drama of impeachment. And third, have the Democrats laid out a case so clear that even the opposition has to agree? Absolutely not. You and House Democrat leadership are tearing apart the country. You said the evidence needs to be clear. It is not. You said offenses need to be grave. They are not. You said that once the evidence is laid out, that the opposition will admit they had to do it. That has not happened. In fact, polling and the fact that not one single Republican voted on the impeachment inquiry resolution or on the Schiff report reveal the opposite is true. In fact, what you and your Democratic colleagues have done is opposite of what you said had to be done. This is a partisan impeachment, and it is tearing the country apart. I take this all to mean that Chairman Nadler, along with the rest of the Democratic caucus, is prepared to continue these entirely partisan, unfair proceedings and traumatize the American people, all for a political purpose. I think that's a shame. That's not leadership. That's a sham. And so I asked Mr. Turley, has Chairman Nadler satisfied his three-pronged test for impeachment?
With all due respect to Chairman, I do not believe that those factors were satisfied.
Thank you. And I want to correct something for the record as well. Repeatedly today and other days, Democrats have repeated what was said in the text of the call. Do me a favor, though, and they imply it was against President Biden, to investigate President Biden. It was not. It was not. In fact, let me read what the transcript says. It says, the President Trump, I would like you to do us a favor, though, because our country has been through a lot and Ukraine knows a lot about it. I would like you to find out what happened with this whole situation with Ukraine. They say CrowdStrike. I guess you have one of your own wealthy people. It says nothing about the Biden, so please stop referencing those two together, and I yield back.
Gentlelady yields back. Ms. Jayapal.
Thank you, Mr. Chairman. This is a deeply grave moment that we find ourselves in, and I thought the threat to our nation was well articulated earlier today by Professor Feldman when you said, if we cannot impeach a president who abuses his office for personal advantage, we no longer live in a democracy, we live in a monarchy, or we live under a dictatorship. My view is that if people cannot depend on the fairness of our elections, then what people are calling divisive today will be absolutely nothing compared to the shredding of our democracy. After the events of Ukraine unfolded, the president claimed that the reason he requested an investigation into his political opponents and withheld desperately needed military aid for Ukraine was supposedly because he was worried about corruption. However, contrary to the president's statements, various witnesses, including Vice President Pence's special advisor Jennifer Williams, testified that the president's request was political. Take a listen.
I found the July 25th phone call unusual because, in contrast to other presidential calls I had observed, it involved discussion of what appeared to be a domestic political matter.
Professor Carlin, is it common for someone who gets caught to deny that their behavior is impermissible?
Almost always.
And one of the questions before us is whether the president's claim that he cared about corruption is actually credible. Now, you've argued before the Supreme Court, and the Supreme Court determined that when assessing credibility, we should look at a number of factors, including impact, historical background, and whether there are departures from normal procedures, correct?
That's correct.
So what we're ultimately trying to do is figure out if someone's explanation fits with the facts. And if it doesn't, then the explanation may not be true. So let's explore that. Lieutenant Colonel Vindman testified that he prepared talking points on anti-corruption reform for President Trump's call with Ukrainian President Zelensky. However, based on the transcripts released of those calls in April and July, President Trump never mentioned these points of corruption. He actually never mentioned the word corruption. Does that go to any of those factors? Is that significant?
Yes, it goes to the one about procedural irregularities, and it also goes to the one that says you look at the kind of things that led up to the decision that you're trying to figure out somebody's motive about.
So let's try another one. Ambassador Volker testified that the president never expressed any concerns to him about corruption in any country other than Ukraine. Would that be relevant to your assessment?
Yes, it would. It goes to the factor about substantive departures.
And Professor Carlin, there is in fact, and my colleague, Mr. McClintock, mentioned this earlier, a process outlined in the National Defense Authorization Act to assess whether countries that are receiving military aid have done enough to fight corruption. In May of 2019, my Republican colleague did not say this, the Department of Defense actually wrote a letter determining that Ukraine passed this assessment. And yet, President Trump set aside that assessment and withheld the congressionally approved aid to Ukraine any way in direct contradiction to the established procedures he should have followed had he cared about corruption. Is that assessment, is that relevant to your assessment?
Yes, that would also go to the factors the Supreme Court's discussed.
And what about the fact, and I think you mentioned this earlier as one of the key things that you read in the testimony, that President Trump wanted the investigations of Burisma and the Bidens announced, but that he actually didn't care whether they were conducted. That was in Ambassador Sondland's testimony. What would you say about that?
That goes to whether the claim that this is about politics is a persuasive claim, because that goes to the fact that it's being announced publicly, which is an odd thing. I mean, maybe Mr. Swalwell could probably answer this better than I because he was a prosecutor, but generally you don't announce the investigation in a criminal case before you conduct it because it puts the person on notice that they're under investigation.
And given all of these facts, and there are more that we don't have time to get to, how would you assess the credibility of the president's claim that he was worried about corruption?
Well, I think you ought to make that credibility determination because you have the sole power of impeachment. If I were a member of the House of Representatives, I would infer from this that he was doing it for political reasons.
If we don't stand up now to a president who abuses his power, we risk sending a message to all future presidents that they can put their own personal political interests ahead of the American people, our national security, and our elections, and that is the gravest of threats to our democracy. I yield back.
The gentlelady yields back. I now recognize Mr. Gohmert for the purpose of a unanimous consent request.
Yes, Mr. Chairman. I would ask unanimous consent to offer article by Daniel Huff.
Without objection, the article will be entered into the record.
Thank you.
I now recognize Mr. Reschenthaler to question the witnesses.
Thank you, Mr. Chairman. I'm starting off today doing something that I don't normally do, and I'm going to quote Speaker of the House, Nancy Pelosi. In March, the Speaker told the Washington Post, and I'm going to quote this, "Impeachment is so divisive to the country that unless there's something so compelling and overwhelming and bipartisan, I don't think we should go down that path because it divides the country." Well, on that, the Speaker and I both agree. And you know who else agrees? The Founding Fathers. The Founding Fathers recognized that crimes warranting impeachment must be so severe, regardless of political party, that there is an agreement that the actions are impeachable. But let's go back to Speaker Pelosi's words just one more time. The Speaker says the case for impeachment must be also compelling. Well, after last month's Shift Show, this is what we learned. There is no evidence that the President directed anyone to tell the Ukrainians that aid was conditioned on investigation. Aside from the mere presumptions by Ambassador Sondland, there is no evidence that Trump was conditioning aid on investigation. And if you doubt me, just go back to the actual transcript, because never in that call was the 2020 election mentioned, and never in that call was military aid mentioned. In fact, President Trump told Senator Johnson on 31 August that aid was not conditioned on investigation. Rather, President Trump was rightfully skeptical about the Ukrainians. Their country has a history of corruption, and he merely wanted the Europeans to contribute more to a problem in their own backyard. But I think we can all agree that it's appropriate for the President, as a steward of taxpayer dollars, to ensure that our money isn't wasted. I said I wasn't going to go back to Speaker Pelosi, but I do want to go back because I forgot. She also said that impeachment should be only pursued when it's quote-unquote overwhelming. So it's probably not good for the Democrats that none of the witnesses who testified before the Intel Committee were able to provide firsthand evidence of a quid pro quo. But I forgot we're calling it bribery now after the focus group last week, and there's no evidence of bribery either. Instead, the two people who did have firsthand knowledge, the President and President Zelensky, both say there was no pressure on the Ukrainians. And again, the transcript of July 25th backs this up. And to go back to Nancy Pelosi one more time, she said that the movement for impeachment should be, quote unquote, bipartisan, which is actually the same sentiment echoed by our chairman, Jerry Nadler, who in 1998 said, and I quote, "There must never be a narrowly voted impeachment supported by one of the major political parties and opposed by another." Well, when the House voted on the Democrats' impeachment inquiry, it was just that. It was the only bipartisan vote was the one imposing the inquiry. The partisan vote was the one to move forward with the inquiry. So we're 0 for 3. Let's face it, this is a sham impeachment against President Trump. It's not compelling, it's not overwhelming, and it's not bipartisan. So even by the Speaker's own criteria, this has failed. Rather, what this is nothing more than a partisan witch hunt which denies the fundamental fairness of our American justice system and denies due process to the President of the United States. The Democrats' case is based on nothing more than thoughts, feelings, and conjectures, and the thoughts and feelings of a few unelected career bureaucrats. And the American people are absolutely fed up. Instead of wasting our time on this, we should be doing things like passing USMCA, lowering the cost of prescription drugs, and working on our failing infrastructure in this country. With that said, Mr. Turley, I've watched as your words have been twisted and mangled all day long. Is there anything you would like to clarify?
Only this. I think that one of the disagreements that we have, and I have with my esteemed colleagues, is what makes a legitimate impeachment, not what technically satisfies an impeachment. There's very few technical requirements of an impeachment. The question is what is expected of you. And my objection is that there is a constant preference for inference over information, for presumptions over proof. That's because this record hasn't been developed. And if you're going to remove a president, if you believe in democracy, if you're going to remove a sitting president, then you have an obligation not to rely on inference when there's still information you can gather. And that's what I'm saying. It's not that you can't do this. You just can't do it this way.
Thank you, Mr. Chairman.
The gentleman yields back. I now recognize Ms. Jackson Lee for the purpose of a unanimous consent request.
Thank you, Mr. Chairman. I'd like unanimous consent to place in the record a new statement from checks and balances on President Trump's abuse of offices
Without objection, the
Republican and Democratic Attorney Generals. I ask unanimous consent.
Without objection, I now recognize Ms. Demings for 5 minutes for questioning the witnesses.
Thank you, Mr. Chairman. As a former law enforcement official, I know firsthand that the rule of law is the strength of our democracy, and no one is above it. Not our neighbors in our various communities, not our co-workers, and not the President of the United States. Yet the President has said that he cannot be prosecuted for criminal conduct, that he need not comply with congressional requests and subpoenas. Matter of fact, the President is trying to absorb himself of any accountability. Since the beginning of the investigation in early September, the House sent multiple letters, document requests, and subpoenas to the White House. Yet the President has refused to produce documents and has directed others not to produce documents. He has prevented key White House officials from testifying. The President's obstruction of Congress is pervasive. Since the House began its investigation, the White House has produced 0 subpoenaed documents. In addition, at the President's direction, more than a dozen members of his administration have defied congressional subpoenas. The following slide shows those who have refused to comply at the President's direction. We are facing a categorical blockade by a president who's desperate to prevent any investigation into his wrongdoing. Professor Gerhardt, has a president ever refused to cooperate in an impeachment investigation?
Not until now.
And any president who, I know Nixon delayed or tried to delay turning over information, when that occurred, was it at the same level that we're seeing today?
President Nixon also had ordered his subordinates to cooperate and testify. He didn't shut down any of that. He produced documents, and there were times, there were certainly disagreements, but there was not a wholesale, broad-scale, across-the-board refusal to even recognize the legitimacy of this House doing an inquiry.
Did President Nixon's obstruction result in an article of impeachment?
Yes, ma'am. Article 3.
Professor Feldman, is it fair to say that if a president stonewalls an investigation like we are clearly seeing today into whether he has committed an impeachable offense, he risks rendering the impeachment power moot?
Yes, and indeed, that's the inevitable effect of a president refusing to participate. He's denying the power of Congress under the Constitution to oversee him and to exercise its capacity to impeach.
Professor Gerhardt, when a president prevents witnesses from complying with congressional subpoenas, are we entitled to make any presumptions about what they would say if they testified?
Yes, ma'am, you are. And I might just point out that one of the difficulties with asking for a more thorough investigation is that's exactly what the House has tried to conduct here. And the president has refused to comply with subpoenas and other requests for information. That's where the blockage occurs. That's why there are documents not produced and why there are people not testifying that people here have said today they want to hear from.
In relation to what you just said, Ambassador Sondland testified, and I quote, "Everyone was in the loop. It was no secret." Professor Gerhardt, how is Ambassador Sondland's testimony relevant here?
His testimony is relevant. It's also rather chilling to hear him say that everybody's in the loop. And when he says that, he's talking about the people at the highest levels of our government, all of whom are refusing to testify under oath or comply with subpoenas.
Professors, I want to thank you for your testimony. The president used the power of his office to pressure a foreign head of state to investigate an American citizen in order to benefit his domestic political situation. After he was caught, and I do know something about that, this president proceeded to cover it up and refused to comply with valid congressional subpoenas. The framers included impeachment in the Constitution to ensure that no one is above the law, including and especially the President of the United States. Thank you, Mr. Chair, and I yield back.
Gentlelady yields back. Mr. Klein is recognized.
Thank you, Mr. Chairman. No, it's just past 5 o'clock, and a lot of families are just getting home from work right now. They're turning on the TV, and they're wondering what they're watching on TV. They're asking themselves, is this a rerun? Because I thought I saw this a couple of weeks ago. But no, this is not a rerun, unfortunately. This is Act 2 of the three-part tragedy, the impeachment of President Trump. And what we're seeing here is several very accomplished constitutional scholars attempting to divine the intent, whether it's of the president or of the various witnesses who appeared during the Schiff hearings. And it's very frustrating to me as a member of the Judiciary Committee why we are where we are today. I asked to be a member of this committee because of its storied history, because it was the defender of the Constitution, because it was one of the oldest committees in the Congress established by another Virginian, John George Jackson. It's because two of my immediate predecessors, Congressman Bob Goodlatte, who chaired this committee, and Congressman Caldwell Butler, also served on this committee. But the committee that they served on is dead. That committee doesn't exist anymore. That committee is gone. Apparently now we don't even get to sit in the Judiciary Committee room. We're in the Ways and Means Committee room. I don't know why. Maybe because there's more room. Maybe because the portraits of the various chairmen who would be staring down at us might just intimidate the other side as they attempt what is essentially a sham impeachment of this president. You know, looking at where we are, the lack of the use of the Rodino rules in this process is shameful. The fact that we got witness testimony for this hearing this morning is shameful. The fact that we got the Intelligence Committee report yesterday, 300 pages of it, is shameful. I watched the Intelligence Committee hearings from the back, although I couldn't watch them all because the Judiciary Committee actually scheduled business during the Intelligence Committee hearings, so the Judiciary Committee members weren't able to watch all of the hearings. But I didn't get to, I get to read the transcripts of the hearings that were held in private. I was not able to be a part of the Intelligence Committee hearings that were in the SCIF. We haven't seen the evidence from the Intelligence Committee yet. We've asked for it. We haven't received it. We haven't heard from any fact witnesses yet before we get to hear from these constitutional scholars about whether or not the facts rise to the level of an impeachable offense. Mr. Turley, it's not just your family and dog who are angry. Many of us on this committee are angry. Many of us watching at home across America are angry because this show has degenerated into a farce. And as I said, the Judiciary Committee of my predecessors is dead. And I look to a former chairman, Daniel Webster, who said, "We are all agents of the same supreme power, the people, and it's the people who elected this president in 2016, and it's the people who should have the choice as to whether or not to vote for this president in 2020, not the members of this committee, not Speaker Nancy Pelosi, and not the members of this House of Representatives. It should be the people of the United States who get to decide who their president is in 2020. I asked several questions about obstruction of justice to Mr. Mueller when he testified. Mr. Turley, I know that you mentioned obstruction of justice several times in your testimony. I want to yield to Mr. Ratcliffe to ask a concise question about that issue.
I thank the gentleman for yielding. Professor Turley, in the last few days we've been hearing that despite no questions to any witnesses during the first 2 months of the first phase of this impeachment inquiry, that the Democrats may be dusting off the obstruction of justice portion of the Mueller report. Seems to me that we all remember how painful it was to listen to special counsel's analysis of the obstruction of justice portion of that report. I'd like you to address the fatal flaws from your perspective with regard to the obstruction of justice portion of that
The gentleman's time has expired. The witness may answer the question briefly.
Thank you, Mr. Chairman. I've been a critic of the obstruction theory behind the Russia investigation because, once again, it doesn't meet what I think are the clear standards for obstruction. There were 10 issues that Mueller addressed. The only one that I think that raised a serious issue, quite frankly, was the matter with Don McGahn. There's a disagreement about that. But also, the Department of Justice rejected the obstruction of justice claim, and it was not just the Attorney General. It was also the Deputy Attorney General, Rod Rosenstein.
The gentleman is well expired. The gentleman's time is well expired. Mr. Correa.
Thank you, Mr. Chairman, and I'd like to thank our witnesses for being here today. I can assure you your testimony is important not only to this body, but to America that is listening very intently on what the issues before us are and why is it so important that all of us understand the issues before us. Professor Feldman, as was just discussed, President Trump has ordered the executive branch to completely blockade the efforts of this House to investigate whether he committed high crimes and misdemeanors in his dealings with the Ukraine. Is that correct?
Yes, it is.
President Trump has also asserted that many officials are somehow absolutely immune from testifying in this impeachment inquiry. On the screen behind you is the opinion by Judge Jackson, a federal judge here in D.C., that rejects President Trump's assertion. Professor Feldman, do you agree with Judge Jackson's ruling that President Trump has invoked a non-existent legal basis to block witnesses from testifying in this impeachment inquiry?
I agree with the thrust of Judge Ketanji Brown Jackson's opinion. I think that she correctly held that there is no absolute immunity which would protect a presidential advisor from having to appear before the House of Representatives and testify. She did not make a ruling as to whether executive privilege would apply in any given situation, and I think that was also appropriate because the issue had not yet arisen.
And let me quote Judge Jackson, open quote, "The primary takeaway from the past 250 years of recorded American history is that presidents are not kings," close quote. Professor Feldman, in the framers' view, does the president act more like a leader of democracy or more like a monarch when he orders officials to defy Congress as it tries to investigate abuse of power and corruption of electeds?
Sir, I don't even think the framers could have imagined that a president would flatly refuse to participate in an impeachment inquiry, given that they gave the power of impeachment to the House of Representatives and assumed that the structure of the Constitution would allow the House to oversee the president.
Thank you. Professor Gerhardt,
Yes.
where can we look in the Constitution to understand whether the president must comply with the impeachment investigations?
I think you can look throughout the entire Constitution. A good place, of course, includes the Supremacy Clause. The president also takes an oath. He takes an oath to support and defend the Constitution of the United States. That means that he's assuming office with certain constraints on what he may do, and that there are measures for accountability for any failure to follow his duty or follow the Constitution.
Thank you. And the president has said that he is above the law, that Article 2 of the Constitution allows him to, and I quote, "do whatever I want." That can't be true. Judge Jackson has said that no one is above the law. Personally, I grew up in California in the 1960s. It was a time when we were going to beat the Russians to the moon. We were full of optimism. We believed in American democracy. We were the best in the world. And back home on Main Street, my mom and dad struggled to survive day to day. My mom worked as a maid cleaning hotel rooms for $1.50 an hour, and my dad worked at a local paper mill trying to survive day to day. And what got us up in the morning was the belief, the optimism that tomorrow was going to be better than today. We're a nation of freedom, democracy, economic opportunity, and we always know that tomorrow is going to be better. And today, I personally sit as a testament to the greatness of this nation, me, out of the hoods in Congress. And I sit here in this committee room also with one very important mission, which is to keep the American dream alive, to ensure that all of us are equal, to ensure that nobody is above the law, and to ensure that our Constitution and that our congressional oversight of the presidency is still something with meaning. Thank you. Mr. Chair, I yield back.
The gentleman yields back. Mr. Armstrong.
Thank you, Mr. Chairman. You know, all day long we've been sitting here and listening to my friends across the aisle and their witnesses claim that the president demanded Ukraine do us a favor by assisting in 2020 re-election campaign before he would release the military aid. This is, like everything else in the sham impeachment, purposefully misleading and not based on the facts. So let's review the actual transcript of the call. They never mentioned the 2020 election. They never mentioned military aid. It does, however, clearly show that the favor the president requested was assistance with the ongoing investigation into the 2016 election. Those investigations, particularly the one being run by U.S. Attorney Jeff Durham, should concern Democrats. And the transcript of this call shows that the president was worried about the efforts of Ukraine relating to the 2016 election. We know this, and notice I'm using the word know and not the word infer, from reading the transcript and because he spoke about it ending with Mueller. We know this because he wants the Attorney General to get in touch with the Ukrainians about the issue. We have a treaty with Ukraine governing these sorts of international investigations. But like so many other things, these facts are inconvenient for Democrats. They don't fit the impeachment narrative, so they're misrepresented or ignored. And I think it's important when we talk about this, and whatever the burden of proof, beyond a reasonable doubt, clear and convincing evidence, whether it's a judicial hearing, a quasi-judicial hearing, or a congressional hearing, when we're talking about these issues, I think we need to start with how we look at it. And I'm not a constitutional law professor, I'm just an old criminal defense attorney. But when I walk into a courtroom, I think of three things. What's the crime charge? What's the conduct? And who's the victim? And we've managed to make it till 5 o'clock today before we've talked about the alleged victim of the crime. And that's President Zelensky. And 3 different times, President Zelensky, at least 3 different times, has denied being pressured by the president. The call shows laughter, pleasantries, cordiality. September 25th, President Zelensky states, "No, you heard that we had a good phone call. It was normal. We spoke about many things. I think you read it, and nobody pushed me." October 10th, President Zelensky had a press conference, and I encourage everybody to watch it. Even if you don't understand it, 90% of communication is nonverbal. You tell me if you think he's lying. There was no blackmail. December 2nd, this Monday, I never talked to the president from the position of quid pro quo. So we have the alleged victim of quid pro quo, bribery, extortion, whatever we're dealing with now today, repeatedly and adamantly shouting from the rooftops that he never felt pressure, that he was not the victim of anything. So in order for this whole thing to stick, we have to believe that President Zelensky is a pathological liar, or that the Ukrainian president and the country are so weak that he has no choice but to parade himself out there, demoralize himself for the good of his country. Either of these 2 assertions weakens their countries and harms our efforts to help the Ukraine. And also begs the question of how on earth did President Zelensky withstand this illegal and impeachable pressure to begin with? Because this fact still has not changed. The aid was released to Ukraine and did not take any action from them in order for it to flow. And with that, I yield to my friend, Mr. Jordan.
I thank the gentleman for yielding. Professor Carlin, context is important, isn't it?
Yes, sir.
Yeah, because just a few minutes ago, when our colleague from Florida presented a statement you made, you said, well, you got to take that statement in context, but it seems to me you don't want to extend the same or apply the same standard to the president. Because the now famous quote, "I would like you to do us a favor," you said about an hour and a half ago that didn't mean us, it meant the president himself. But that's the clear reading of this, "I would like you to do us a favor, though, because," you know what the next 2 words are?
I don't have the document.
I'll tell you, because our country. He didn't say, "I would like you to do me a favor, though, because I have been through a lot." He said, "I want you to do us a favor, though, because our country has been through a lot." You know what when this call happened? Happened the day after Mueller was in front of this committee. Of course, our country was put through 2 years of this. And the idea that you're now going to say, "Oh, this is the royal we," and he's talking about himself, ignores the entire context of his statement. That whole paragraph, you know what he ends that paragraph with? Talking about Bob Mueller. And this is the basis for this impeachment, this call. It couldn't be further from the truth. You want the standard to apply when Representative Gates makes one of your statements. Oh, you got to look at the context. But when the President of the United States is clear, you try to change his word, and when the context is clear, he's talking about the 2 years that this country went through because of this Mueller report. Somehow that standard doesn't apply to the President. That is ridiculous.
The gentleman's time has expired. Ms. Scanlon.
I want to thank our constitutional experts for walking us through the framers' thinking on impeachment and why they decided it was a necessary part of our Constitution. I'm going to ask you to help us understand the implications of the President's obstruction of Congress's investigation into his use of the office of the President to squeeze the Ukrainian government to help the Trump re-election campaign. And there's certainly hundreds of pages on how one reaches that conclusion. We know the President's obstruction did not begin with the Ukraine investigation. Instead, his conduct is part of a pattern, and I'll direct your attention to the timeline on the screen. In the left-hand column, we see the President's statement from his July call in which he pressured Ukraine, a foreign government, to meddle in our elections. Then once Congress got wind of it, the President tried to cover up his involvement by obstructing the congressional investigation and refusing to cooperate. But this isn't the first time we've seen this kind of obstruction. In the right-hand column, we can flash back to the 2016 election when the President welcomed and used Russians' interference in our election. And again, when the special counsel and then this committee tried to investigate the extent of his involvement, he did everything he could to cover it up. So it appears the President's obstruction of investigations is part of a pattern. First, he invites foreign powers to interfere in our elections. Then he covers it up. And finally, he obstructs lawful inquiries into his behavior, whether by Congress or law enforcement. And then he does it again. So, Professor Gerhardt, how does the existence of such a pattern help determine whether the president's conduct is impeachable?
The pattern, of course, gives us a tremendous insight into the context of his behavior, when he's acting, and how do we explain those actions? By looking at the pattern. And we can infer I think a very strong inference, in fact, is that this is deviating from the usual practice, and he's been systematically heading towards a culmination where he can ask this question. By the way, after the July 25th call, the money's not yet released. It's not, and there's ongoing conversations we learned from other testimony that essentially the money is being withheld because the president wanted to make sure the deliverable was going to happen, that is the announcement of an investigation.
And in addition to the money not being released, there also was not the White House meeting, which was so important to Ukrainian security, right?
Yes, ma'am, that's right.
Okay. Professor Feldman, we noted previously that a federal district court recently rejected the president's attempt to block witnesses from testifying to Congress, saying that presidents are not kings. The founders included two critical provisions in our Constitution to prevent our president from becoming a king and our democracy from becoming a monarchy. And those protections were presidential elections and impeachment, correct?
Correct.
Based on the pattern of conduct that we're discussing today, the pattern of inviting foreign interference in our elections for political gain and then obstructing lawful investigation, has the president undermined both of those protections?
He has, and it's crucial to note that the victim of a high crime and misdemeanors, such as the president's alleged to have committed, is not President Zelensky and is not the Ukrainian people. The victim of the high crime and misdemeanor is the American people. Alexander Hamilton said very clearly that the nature of a high crime and misdemeanor is that they are related to injuries done to the society itself. We, the American people, are the victims of the high crime and misdemeanor.
And what is the appropriate remedy in such a circumstance?
The framers created one remedy to respond to high crimes and misdemeanors, and that was impeachment.
Thank you. You know, I've spent over 30 years working to help clients and school children understand the importance of our constitutional system and the importance of the rule of law. So the president's behavior is deeply, deeply troubling. The president welcomed and used election interference by Russia, publicly admitted he would do it again, and did in fact do it again by soliciting election interference from Ukraine. And throughout, the president has tried to cover up his misconduct. This isn't complicated. The founders were clear, and we must be too. Such behavior in a president of the United States is not acceptable. I yield back.
The gentlelady yields back. Mrs. Cicilline, be recognized for unanimous consent request.
Mr. Chairman, I ask unanimous consent that a document which lists the 400 pieces of legislation passed by the House, 275 bipartisan bills, 80% which remain languishing in the Senate, be made a part of the record in response to Mr. Gates' claim that we're not getting the work done.
Without objection, the document will be made part of the record. Mr. Biggs is recognized for unanimous consent request.
Yes, Mr. Chairman, I seek unanimous consent for a packet of 54 documents and items which have previously been submitted.
Without objection, the documents will be entered into the record.
Mr. Chairman, may I have another unanimous?
What purpose does the gentleman seek?
Mr. Chairman, I ask unanimous consent that this article that was just published about 15 minutes ago entitled Law Professor Jonathan Turley Said Democrats Are Setting a Record for a Fast Impeachment, that's demonstrably false, be made part of the record.
Without objection.
Mr. Chairman.
Without objection, the document will be made part of the record. Who seeks recognition?
Mr. Chairman.
What purpose does the gentleman seek recognition?
I seek unanimous consent to enter into a record a tweet that the First Lady of the United States just issued within the hour that says, quote, "A minor child deserves privacy and should be kept out of politics. Pamela Karlan, you should be ashamed of your very angry and obviously biased public pandering and using a child to do it," unquote.
Without objection, the document will be entered into the record. Mr. Stubbe is recognized for the purpose of questioning the witnesses. I'm sorry. Who did I say passed? Mr. Stubbe is not here momentarily. Ms. Garcia is recognized.
Thank you, Mr. Chairman, and I too want to thank all the witnesses for their time and their patience today. I know it's been a long day, but the end is in sight. As my colleague, Ms. Scanlon, observed, The similarities between the president's conduct in the Ukraine investigation and his conduct in the special counsel's investigation are hard to ignore. In fact, we're seeing it as a pattern of a presidential abuse of power. The president called the Ukraine investigation a hoax and the Mueller investigation a witch hunt. He has threatened the Ukraine whistleblower for not testifying, like he threatened to fire his attorney general for not obstructing the Russia investigation. The president fired Ambassador Yovanovitch and publicly tarnished her reputation much in the same way he fired his White House counsel and publicly attacked his integrity. And finally, the president attacked the civil servants who have testified about Ukraine, just like he attacked career officials of the Department of Justice for investigating his obstruction of the Russia investigation. Under any other circumstances, such behavior by any American president would be shocking. But here, it is a repeat of what we have already seen in the special counsel's investigation. I'd like to take a moment to discuss the president's efforts to obstruct the special counsel's investigation, a subject that this committee has been investigating since March. Here are two slides. The first one will show as he did with the president, as he did with Ukraine, tried to coerce his subordinates to stop an investigation into his misconduct by firing special counsel Mueller. In the second slide, this shows that when the news broke out of the president's order, the president directed his advisors to falsely deny he had made the order. Professor Gerhardt, are you familiar with the facts relating to these three episodes as described in the Mueller report? Yes or no, please?
Yes, ma'am.
So, accepting the special counsel's evidence is true, is this pattern of conduct obstruction of justice?
It's clearly obstruction of justice.
And why would you say so, sir?
The obvious object of this activity is to shut down an investigation. And in fact, the acts of the president, according to these facts, each time is to use the power that he has unique to his office, but in a way that's going to help him frustrate the investigation.
So does this conduct fit within the framers' view of impeachable offenses?
I believe it does. I mean, the entire Constitution, including separation of powers, is designed to put limits on how somebody may go about frustrating the activity of another branch.
So you would say that this also would be an impeachable offense?
Yes, ma'am.
Well, thank you, because I agree with you. The president's actions and behavior do matter. The president's obstruction of justice definitely matters. As a former judge and as a member of Congress, I've raised my right hand and put my left hand on a Bible more than once, and I've sworn to uphold the Constitution and laws of this country. This hearing is about that, but it's also about the core of the heart of our American values, the values of duty, honor, and loyalty. It's about the rule of law. When the president asked Ukraine for a favor, he did so for his personal political gain and not on behalf of the American people. And if this is true, he would have betrayed his oath and betrayed his loyalty to this country. A fundamental principle of our democracy is that no one is above the law. Not any one of you professors, not any one of us up here, members of Congress, not even the President of the United States. That's why we should hold him accountable for his actions, and that's why again, thank you for testifying today and helping us walk through all this to prepare for what may come. Thank you, sir. I yield back.
Gentlelady yields back. Mr. Neguse.
Thank you, Mr. Chair, and thank you to each of the four witnesses for your testimony today. I'd like to start by talking about intimidation of witnesses. As my colleague, Congresswoman Garcia, noted, President Trump has tried to interfere in both the Ukraine investigation and Special Counsel Mueller's investigation in order to try to cover up his own misconduct. And in both the Ukraine investigation and Special Counsel Mueller's investigation, the president actively discouraged witnesses from cooperating, intimidated witnesses who came forward, and praised those who refused to cooperate. For example, in the Ukraine investigation, the president harassed and intimidated the brave public servants who came forward. he publicly called the whistleblower a, quote, disgrace to our country, and said that his identity should be revealed. He suggested that those involved in the whistleblower complaint should be dealt with in the way that we, quote, used to do, end quote, for spies and treason. He called Ambassador Taylor, a former military officer with more than 40 years of public service, a, quote, never-Trumper, end quote, on the same day that he called never-Trumpers, quote, scum. The president also tweeted accusations about many of the other public servants who testified, including Jennifer Williams and Ambassador Yovanovitch. And as we know, the president's latter tweet happened literally during the ambassador's testimony in this room in front of the Intelligence Committee, which she made clear was intimidating. Conversely, we know that the president has praised witnesses who have refused to cooperate. For example, during the special counsel's investigation, the president praised Paul Manafort, his former campaign manager, for not cooperating. You can see the tweet up on the screen to my side. As another telling example, the president initially praised Ambassador Sondland for not cooperating, calling him, quote, a really good man and a great American. But after Ambassador Sondland testified and confirmed that there was indeed a quid pro quo between the White House visit and the request for investigations, the president claimed that he, quote, hardly knew the ambassador. Professor Gerhardt, you've touched on it previously, but I'd like you to just explain, is the president's interference in these investigations by intimidating witnesses also the kind of conduct that the framers were worried about, and if so, why?
It's clearly conduct, I think, that worried the framers as reflected in the Constitution they've given us, in the structure of that Constitution. The activities you're talking about here are consistent with the other pattern of activity we've seen with the president either trying to stop investigations, either by Mr. Mueller or by Congress, as well as to ask witnesses to make false documents about testimony. And all those different kinds of activities are not the kinds of activities the framers expected the president to be able to take. They expect the president to be held accountable for it, and not just in elections.
Professor Turley, you've studied the impeachments of President Johnson, President Nixon, President Clinton. Am I right that President Nixon allowed senior White House officials, including the White House counsel and the White House chief of staff, to testify in the House impeachment inquiry?
Yes.
And you're aware that President Trump has refused to allow his chief of staff or White House counsel to testify in this inquiry, correct?
Yes, but various officials did testify, and they are remaining in federal employment.
And that does not include the White House counsel nor the White House chief of staff, correct?
That's correct.
And am I right that President Clinton provided written responses to 81 interrogatories from the House Judiciary Committee during that impeachment inquiry?
I believe that's correct.
Sounds about right. And you're aware that President Trump has refused any requests for information submitted by the Intelligence Committee in this impeachment inquiry?
I have, yes.
Are you familiar with the letter issued by White House counsel Pat Cipollone on October 8th, written on behalf of President Trump, and in effect instructing executive branch officials not to testify in this impeachment inquiry?
Yes, I am.
And am I correct that no president in the history of the Republic before President Trump has ever issued a general order instructing executive branch officials not to testify in an impeachment inquiry?
That's where I'm not sure I can answer that affirmatively. I mean, President Nixon, in fact, went to court over access to information, documents, and the like, and he lost.
Well, Professor Turley, I would just, again, refer you back to the history that's been recounted by each of the distinguished scholars here today, because we know, as we recount these examples, that President Nixon did, in fact, allow his chief of staff and his chief counsel to testify, and this president has not. We know that President Clinton responded to interrogatories propounded by that impeachment inquiry, and that this president has not. At the end of the day, this Congress and this committee has an obligation to ensure that the law is enforced. And with that, I yield back the balance of my time.
Gentleman yields back. Ms. McBath.
Thank you, Mr. Chairman. And professors, I want to thank you so very much for spending these long, arduous hours with us today. Thank you so much for being here. Following up on my colleague, Mr. Negus's questions, I'd like to briefly go through one particular example of the president's witness intimidation that I find truly disturbing and very devastating. because I think it's important that we all truly see what's going on here. As the slide shows, on his July 25th call, President Trump said that former Ambassador Yovanovitch would, and I quote, go through some things. Ambassador Yovanovitch testified about how learning about the president's statements made her feel.
What did you think when President Trump told President Zelensky, and you read, that you were going to go through some things?
I didn't know what to think, but I was very concerned.
What were you concerned about?
She's going to go through some things. It didn't sound good. It sounded like a threat.
Did you feel threatened?
I did.
And as we all witnessed in real time, in the middle of Ambassador Yovanovitch's live testimony, the president tweeted about the ambassador, discrediting her service in Somalia and the Ukraine. Ambassador Yovanovitch testified that the president's tweet was, and I quote, very intimidating. Professor Gerhardt, these attacks on a career public servant are deeply upsetting. But how do they fit into our understanding of whether the president has committed high crimes and misdemeanors? And how do they fit into our broader pattern of behavior by this president to cover up and obstruct his misconduct?
One way in which it contributes to the obstruction of Congress is that it doesn't just defame Ambassador Yovanovitch. By every other account, she's been an exemplary public servant. So what he's suggesting there may not be consistent with what we know as facts. But one of the things that also happens when he sends out something like this, it intimidates everybody else who's thinking about testifying, any other public servants that think they should come forward. They're going to worry that they're going to get punished in some way. They're going to face things like she's faced.
That is the woman President Trump has threatened before you. And I can assure you, I personally know what it's like to be unfairly attacked publicly for your sense of duty to America. Ambassador Yovanovitch deserves better. No matter your party, whether you're a Democrat or Republican, I don't think any of us thinks that this is okay. It is plainly wrong for the President of the United States to attack a career public servant just for telling the truth as she knows it. And I yield back the balance of my time.
The gentlelady yields back. Mr. Stanton.
Thank you very much, Mr. Chairman, and thank you to our outstanding witnesses here today. President Trump has declared that he will not comply with congressional subpoenas. This blanket categorical disregard of the legislative branch began with the president's refusal to cooperate with regular congressional oversight and has now extended to the House's constitutional duty on impeachment, the reason why we are here today. This disregard has been on display for the American people. When asked if he would comply with the Don McGahn subpoena, President Trump said, quote, "Well, we're fighting all the subpoenas," unquote. Now, we've discussed here today the obstruction of Congress, article impeachment against President Nixon. But I think I'd like to go a little bit deeper into that discussion and juxtapose it with the President Trump's actions. Professor Gerhardt, can you elaborate on how President Nixon obstructed Congress and how it compares to President Trump's actions?
As I was discussing earlier and included in my written statement, President Nixon ultimately refused to comply with 4 legislative subpoenas. These were zeroing in on the most incriminating evidence he had in his possession. So he refused to comply with those subpoenas, became the basis for that 3rd article, and he resigned a few days later.
Professor Feldman, what are the consequences of this unprecedented obstruction of Congress to our democracy?
For the president to refuse to participate in any way in the House's constitutional obligation of supervising him to impeach him breaks the Constitution. It basically says, nobody can oversee me. Nobody can impeach me. First, I'll block witnesses from appearing, then I'll refuse to participate in any way, and then I'll say, you don't have enough evidence to impeach me. And ultimately, the effect of that is to guarantee that the president is above the law and can't be checked. And since we know the framers put impeachment in the Constitution to check the president, if the president can't be checked, he's no longer subject to the law.
Professor Gerhardt, would you agree that the president's refusal to comply with congressional subpoenas invokes the framers' worst fears and endangers our democracy?
It does, and one way in which to understand that is to put all of his arguments together and then see what the ramifications are. He says he's entitled not to comply with all subpoenas. He says he's not subject to any kind of criminal investigation while he's president of the United States. He's immune to that. He's entitled to keep all information confidential from Congress. Doesn't even have to give a reason. Well, when you put all those things together, he's blocked off every way in which to hold himself accountable except for elections. And the critical thing to understand here is that is precisely what he was trying to undermine in the Ukraine situation.
Professor Carlin, do you have anything to add to that analysis?
Thanks. I think that's correct. And if I can just say one thing. I want to apologize for what I said earlier about the president's son. It was wrong of me to do that. I wish the president would apologize, obviously, for the things that he's done that's wrong, but I do regret having said that.
Thank you, Professor. One of the most important questions that every member of this committee must decide is whether we are a nation of laws and not men. It used to be an easy answer, one we could all agree on. When President Nixon defied the law and obstructed justice, he was held to account by people on both sides who knew that for our republic to endure, we must have fidelity to our country rather than one party or one man. And the obstruction we're looking at today is far worse than President Nixon's behavior. Future generations will measure us, every single member of this committee, by how we choose to answer that question. I hope we get it right. I yield back.
The gentleman yields back. Mr. Stubbe.
Thank you, Mr. Chairman. I've only been in Congress since January of this year, and on the very first day of my swearing in, a Democrat in my class called for the impeachment of the president on day one, using much more colorful language than I would ever use. Since then, this committee focused on the Mueller report and the Russia collusion theory. We all sat and listened to Mr. Mueller state unequivocally that there was no evidence that the Trump campaign colluded with Russia. So that didn't work for the Democrats. So they then changed their talking points and moved to the obstruction of justice theory, that the president obstructed justice. Then that fizzled. Then after coordinating with Chairman Schiff's staff, a whistleblower filed a complaint based completely on hearsay and overhearing other people that weren't on a phone call talk about a phone call between two world leaders, which led to the Intel Committee so-called impeachment inquiry, which violated all past historical precedent, denied the president basic due process rights and fundamental fairness by conducting the so-called inquiry in secret, without the minority's ability to call witnesses, and denied the president the ability to have his lawyers cross-examine witnesses, a right afforded to President Clinton and every defendant in our justice system, including rapists and murderers. The Republicans on this committee have repeatedly requested all evidence collected by the Intel Committee. As we sit here today, we still don't have the underlying evidence that we've been requesting. Again, a right afforded every criminal defendant in the United States. So instead, we sit here getting lectures from law professors about their opinions, not facts. I guess the Democrats needed a constitutional law refresher course. The Republicans don't. Mr. Chairman, you have acknowledged, and I quote, the House's, quote, power of impeachment demands a rigorous level of due process. Due process means the right to confront witnesses against you, to call your own witnesses, and to have the assistance of counsel. Those are your words, Mr. Chairman, not mine. What are you afraid of? Let the minority call witnesses. Let the president call witnesses. Clinton alone called 14 witnesses to testify. Let the president's counsel cross-examine the whistleblower. Let the president's counsel cross-examine the Intel staff who colluded with the whistleblower. In your own words, those are the rights that should be afforded to the president. rights every criminal defendant is afforded. Even terrorists in Iraq were afforded more due process than you and the Democratic majority have afforded the president. I know, because I served in Iraq, and I prosecuted terrorists in Iraq, and we provided terrorists in Iraq more rights and due process in the Central Criminal Court of Iraq than you and Chairman Schiff have afforded the President of the United States. No collusion, no obstruction, no quid pro quo, no evidence of bribery except opinion, no evidence of treason, no evidence of high crime or misdemeanors. We have a bunch of opinions from partisan Democrats who have stated from day one that they want to impeach the president, and not on this theory, but on multiple other different theories. The American people are smarter than your ABCs of impeachment that you've had on the screen that were laid out today. And it's extremely demonstrative of your lack of evidence, giving you called law professors to give their opinions and not fact witnesses to give their testimony today to be cross-examined and the rights afforded to the President of the United States. Mr. Chairman, when can we anticipate that you will choose a date for the minority day of hearings? Mr. Chairman, I'm asking you a question. When can we anticipate that you will choose a date for the minority day of hearings?
The gentleman is recognized for the purpose of questioning the witnesses, not for colloquy with colleagues.
Well, then I'll do that after my time. I yield the remainder of my time to Mr. Ratcliffe.
I thank my colleague from Florida for yielding. Professor Turley, since we last talked, based on questioning from my colleagues across the aisle, it does in fact appear that the Democrats do intend to pursue articles of impeachment for obstruction of justice based on the Mueller report. I asked you a question about that. You didn't really get a chance to give a complete answer. In your statement today, you make this statement: I believe an obstruction claim based on the Mueller report would be at odds with the record and the controlling law. The use of an obstruction theory from the Mueller report would be unsupportable in the House and unsustainable in the Senate. Do you remember writing that?
Yes, I do.
Why did you write that?
Because I think it's true. The fact is that this was reviewed by Maine Justice. The special counsel did not reach a conclusion on obstruction. He should have. I think that his justification, quite frankly, was a bit absurd on not reaching a conclusion, but the Attorney General and Deputy Attorney General did, and they came to the right conclusion. I don't think this is a real case for obstruction, but then this body would be impeaching the president on the basis of the inverse conclusion. I don't believe it would be appropriate.
Gentleman's time has expired. Ms. Dean.
Thank you, Mr. Chairman. Words matter. In my earlier life, professors, I was a professor of writing. I taught my students to be careful and clear about what they put to paper. That is a lesson that the framers of our Constitution understood far better than anyone. They were laying the foundation for a new form of government, one that enshrines democratic principles and protects against those who would seek to undermine them. The Constitution explicitly lays out that a president may be impeached for treason, bribery, high crimes, and misdemeanors. We've heard a lot of words today: foreign interference, bribery, obstruction of justice. Professors, I'd like to go through the president's conduct and the public harms we have discussed today and ask if they would fit into what the forefathers contemplated when crafting those words of the impeachment clause. Professor Carlin, I'd like to ask you about the foreign interference in elections. As Americans, we can agree foreign interference, foreign influence erodes the integrity of our elections, and as you said so plainly, it makes us less free. Yet on July 25th, 2019, the president coerced Ukrainian President Zelensky to announce an investigation into his political rival, Trump's political rival, which was corroborated by multiple witnesses throughout the Intelligence Committee hearings. Professor Carlin, can you explain for the American people, in your opinion, whether the framers considered solicitation of foreign interference, and would they have considered it a high crime or misdemeanor? And does the president's conduct rise to that level?
The framers of our Constitution would have considered it abhorrent, would have considered it the essence of a high crime or misdemeanor for a president to invite in foreign influence, either in deciding whether he will be reelected or deciding who his successor would be.
Thank you. Professor Feldman, I'd like to talk to you about bribery. During the course of the Intelligence Committee hearings, multiple witnesses gave sworn, unrebutted testimony that the president withheld nearly $400 million in congressionally approved aid on the condition that that Ukraine announce investigations into his chief political adversary. Professor, in your opinion, given those facts and the framers' specific concerns, would you describe the president's behavior here and the use of his public office for a private benefit as rising to those levels?
The framers considered, as you said, bribery under the Constitution to consist of the president abusing his office corruptly for personal gain. If this House determines, and if this committee determines, that the president was in fact seeking personal gain in seeking the investigations that he asked for, then that would constitute bribery under the Constitution.
Thank you. Professor Gerhardt, I'd like to ask you about obstruction of justice. The president has categorically refused to produce any documents responsive to congressional subpoenas, attacked and intimidated prospective and actual witnesses, including career and military and civil servants, as discussed here, like Ambassador Yovanovitch, Lieutenant Colonel Vidman, Ambassador Taylor, Jennifer Williams, and others. And he directed all current and former administration witnesses to defy congressional subpoenas. Professor, based on that set of facts, does this conduct meet the threshold for obstruction of justice as envisioned in the Constitution?
Yes, ma'am, I believe it does. I remember when I was here 21 years ago, along with Professor Turley, testifying before a differently constituted committee on a very serious question regarding impeachment. And I remember a number of law professors very eloquently talking about President Clinton's misconduct as an attack on the judicial system. And that's what you just described to me.
Thank you, and thank you, professors, all of you, all four of you. What you did today is you brought part of our Constitution to life, and I thank you for that. You've shown what the framers were mindful of when they wrote the impeachment clause of our Constitution. They chose their words, and their words matter. You know, it was my father, Bob Dean, a terrific dad and a talented writer, who instilled in me and my brothers and sister a love of language. He taught us our words matter. The truth matters. It's through that lens which I see all of the serious and somber things we're speaking about today: foreign interference, bribery, obstruction. The framers likely could not have imagined all three concerns embodied in a single leader, but they were concerned enough to craft the remedy: impeachment. The times have found us. I am prayerful for our president, for our country, for ourselves. May we, the people, always hold high the decency and promise and ambition of our founding, and of the words that matter, and of the truth. With that, I yield back, Mr. Chairman.
The gentlelady yields back. Ms. McCarcel-Powell.
Thank you, and thank you, professors, for your time today. It's been a long day. I want to tell you, I did not have the privilege of being born into this country. As an immigrant, when I became a citizen to this great nation, I took an oath to protect and defend the Constitution from all foreign and domestic enemies. And I had the fortune of taking that oath once again when I became a member of Congress. And that includes the responsibility to protect our nation from continuing threats from a president, any president. You testified that the president's actions are a continuing risk to our nation and democracy, meaning that this is not a one-time problem. There is a pattern of behavior by the president that is putting at risk fair and free elections. And I think that we are here today because the American people deserve to know whether we need to remove the president because of it. During the Nixon impeachment, the Judiciary Committee said, quote, "The purpose of impeachment is not personal punishment. Its function is primarily to maintain constitutional government." Professor Carlin, to me that means that impeachment should be used when we must protect our American democracy. It is reserved for offenses that present a continuing risk to our democracy. Is that correct?
Yes, it is.
Thank you. And I want to show you an example of what the president said just 1 week after the transcript of the July 25th call was released, when a reporter asked the president what he wanted from President Zelensky, and he responded with this.
Well, I would think that if they were honest about it, they'd start a major investigation into the Bidens. It's a very simple answer. they should investigate the Bidens, because how does a company that's newly formed, and all these companies, if you look at, and by the way, likewise, China should start an investigation into the Bidens, because what happened in China is just about as bad as what happened with Ukraine.
So we've heard today conflicting dialogue from both sides. And I just want to ask Mr. Feldman, is this clear evidence from a president asking for a foreign government to interfere in our elections?
Congresswoman, I'm here for the Constitution. We're here for the Constitution. And when the President of the United States asks for assistance from a foreign power to distort our elections for his personal advantage, that constitutes an abuse of office, and it counts as a high crime and misdemeanor, and that's what the Constitution is here to protect us against.
Thank you. And Professor Carlin, are the president's actions a continuing risk that the framers intended impeachment to be used for?
Yes, this takes us back to the quotation from William Davey that we've all used several times in our testimony, which is, a president without impeachment, a president will do anything to get reelected.
Thank you. And I want to show you one more example from the president's chief of staff when asked about the president's demands of the Ukrainian president.
But to be clear, what you just described is a quid pro quo. It is funding will not flow unless the investigation into the Democratic server happen as well.
We do that all the time with foreign policy. Well, McKinney said yesterday that he was really upset with the political influence in foreign policy. That was one of the reasons he was so upset about this. And I have news for everybody. Get over it. There's going to be political influence in foreign policy.
Professor Carlin.
I think that Mr. Mulvaney is conflating or confusing two different notions of politics. Yes, there is political influence on our foreign affairs. Because President Trump won the election in 2016, we've exited climate accords. We've taken a different position on NATO than we would have taken had his opponent won. But that's different than saying that partisan politics in the sense of electoral manipulation is something that we need to get over or get used to. If we get over that or we get used to that, we will cease to become the democracy that we are right now.
Thank you, and I think that that is our greatest fear and threat. And I don't think that anyone is above the law. The Constitution establishes that. This type of behavior cannot be tolerated from any president, not now, not in the future. And I yield back.
Who have I missed? I'm sorry, Ms. Escobar. I had her checked off for some reason. Ms. Escobar is recognized.
Thank you, Chairman. Professors, thank you so much for your testimony and time today. Many facts, including the President's own words in that famous phone call, have been laid out before our very eyes and ears for months, despite the President's repeated efforts at a cover-up. But it appears that some have chosen to ignore those facts. What we've seen today from those who choose to turn a blind eye is not a defense of the President's actions because, frankly, those offenses are indefensible. Instead, we've seen them attack the process and attempt to impugn your integrity. For that, I'm sorry. Now to my questions. Some have opined that instead of considering impeachment, we should just let this pass and allow the people to decide what to do next or what to do about the President's behavior in the next election. The framers of our Constitution specifically considered whether to just use elections and not have impeachment and rejected that notion. One statement from the framers really stuck with me, and it's up on the screen. George Mason asked, "Shall the man who has practiced corruption, and by that means procured his appointment in the first instance, be suffered to escape punishment by repeating his guilt?" Professor Feldman, I have two questions for you. Briefly, can you please explain why the framers decided that a corrupt executive could not be solved through elections? And can you tell us why impeachment is the appropriate option at this point, considering all the evidence Americans have seen and heard, rather than just letting this be decided in the next election?
The framers understood human motivation extremely well, and they knew that a president would have a great motive to corrupt the electoral process to get reelected. And that's exactly why they thought that it wasn't good enough to wait for the next election, because the president could cheat and could make the next election illegitimate. That's why they required impeachment. And if they couldn't impeach a corrupt president, James Madison said, that could be fatal to the republic. The reason that it's necessary to take action now is that we have a president who has, in fact, sought to corrupt the electoral process for personal advantage. Under those circumstances, the framers' remedy of impeachment is the only option available.
Thank you. I want to play two clips, the first of President Nixon and the second of President Trump.
Well, when the president does it, that means that it is not illegal.
Then I have an Article 2 where I have the right to do whatever I want as president.
Two presidents openly stating that they are above the law. Professor Carlin, what happens to our republic, to our country, if we do nothing in the face of a president who sees himself above the law, who will abuse his power, who will ask foreign governments to meddle in our elections, and who will attack any witness who stands up to tell the truth? What happens if we don't follow our constitutional obligation of impeachment to remove that president from office?
We will cease to be a republic.
Thank you. I represent a community that a little over a decade ago was marred by corruption at the local government level. There was no retreat into a partisan corner or an effort by anyone to explain it away. We also didn't wait for an election to cure the cancer of corruption that occurred on our watch. We were united as a community in our outrage over it. It was intolerable to us because we knew that it was a threat to our institutions, institutions that belong to us. What we face today is the same kind of test, only one far more grave and historic. From the founding of our country to today, one truth remains clear. The impeachment power is reserved for conduct that endangers democracy and imperils our Constitution. Today's hearing has helped us to better understand how we preserve our republic and the test that lies ahead for us. Thank you, Mr. Chairman. I yield back my time.
The gentlelady yields back. That concludes the testimony under the 5-minute rule. I now recognize the ranking member for any concluding remarks he may have.
Thank you, Mr. Chairman. Well, today has been interesting, I guess, to say the least. It has been, we have found many things. In fact, 3 of our 4 witnesses here today alleged numerous crimes committed by the president. And at times it seemed like we were even trying to make up crimes as we go out. Well, if it wasn't this, well, it was the intent to do it. It went along that is interesting today as I started this day, and I'm going to come back to it now. As much as I respect these who came before us today, this is way too early. Because we've not, as a committee, done our job. We've not, as a committee, come together, looked at evidence, taken fact witnesses, put people here in front of us under oath to say what happened and how did it happen and why did it happen. We're taking the work of the Intel Committee and the other committees. We're taking it seemingly at face value, and I will remind all that the chairman even is the biggest proponent of this not happening in his earlier statements almost 20 years ago when he said we should not take a report from another entity and just accept it, otherwise we are a rubber stamp. Now, to my Democratic majority, they may not care, because as I've said before, this is about a clock and a calendar. A clock and a calendar. They're so obsessed with the election next year that they just gloss over things. In fact, what is interesting is, as I said earlier, 3 of the 4 witnesses alleged numerous crimes committed by the president. However, during the Intel Committee hearings, none of the fact witnesses identified a crime. If you're writing about this, that should alarm you. So this impeachment narrative being spun by the majority is a fake one. It's majority spinning 3% of the facts while ignoring 7% of the other. In fact, Professor Turley earlier said today, impeachment needs proof, not presumptions. We have one of the fact witnesses in the Intel Committee. I presumed that was what was going on, Mr. Sonderland. You know what is happening here today is also we found out today. I thought it was really interesting. This is the Judiciary Committee, but we also found out something today, that facts don't matter. In fact, facts don't matter unless we can fit those facts to fit the narrative we want to spin before this committee and the American people. If they don't matter, we also heard one of the witnesses state today that it doesn't matter if aid was released or not. Of course it matters. But unfortunately, the only one of the many facts ignored by the majority. They're ignoring a ton of substantive facts that matter. It apparently doesn't matter to the Democrats that Ambassador Volker, the former special envoy to the Ukraine, made clear in his testimony there was no conditionality on the White House meeting or the aid. The Democrats and their witnesses haven't mentioned that because it's unhelpful to the narrative they're spinning. It apparently doesn't matter that to the Democrats and the majority here, that the president did not condition his aid on an investigation. In fact, Mr. Sondland's statement is to the contrary, was presumption. It was right here in this room. He called it a guess, right where you're sitting. Called it a guess, a presumption. That's what he thought. God forbid if we walk into our courtrooms or in our proceedings now to find somebody guilty of something we're calling a crime, and we walk into court now and all of a sudden, well, I thought it was. The witness said, I presumed it was. God forbid this is where we're at. But you know, we've also heard today that you can make inference, though. It's okay if you're just inferring. I don't know about the professors here, for those of us in court on both sides of the aisle, I've never heard anyone go in and hear a judge say, just infer what you think they meant, and that'll be enough. It's not inference. You know, it probably doesn't matter that the president didn't condition a meeting on an investigation. He met with Zelensky with no preconditions. Zelensky didn't even find out about the hold on the aid until it was after a month after the call when he read it in Politico. The aid was released shortly thereafter, and Ukraine didn't have anything to do to get the aid released. Not only was the aid released, but lethal aid was given as well. And if you think that doesn't matter, there were 5 meetings between the time the aid was stopped and the time the aid was released, and in none of those meetings, between ambassadors and others, including the vice president and senators, none of that was ever connected to a promise of anything on the aid. Nothing was ever connected. 5 times. And 2 of those were after President Zelensky learned that aid was being held. Tell me there's not a problem here with the story. That's why fact witnesses aren't here right now. The evidence against the president is really about policy differences. In fact, 3 of the Democratic star witnesses, Hill, Taylor, and Kent, weren't even on the call. They read transcripts like everyone else. On July 26, Zelensky met with Volker and Sondland and made no reference to quid pro quo or hold on aid. They met several more times, no references. But none of these inconvenient facts or so many other inconvenient facts matter to the majority. Moreover, we don't even know what, if additional hearings, we will have to address other facts. This is the part that bothers me greatly. It is something we have seen from January of this year. No concern about a process that works, but simply a getting to an end that we want. You know, I agree with Professor Feldman. He may find that strange, but I do agree with you on something. It's not his job to assess the credibility of witnesses, it's this committee's job. And I agree. But this committee can't do our jobs if none of the witnesses testify before our committee, even ones that we have talked about calling today, and the majority has said we don't want. To do that, we still don't have an answer on what this committee will do once this hearing ends. The committee received Mr. Chairman Schiff's report yesterday, but we still don't have the underlying evidence. The rules even set up by this body are not being followed to this day, but yet nobody talks about it on the majority side. The witnesses produced by Chairman Schiff and the American people talked about their feelings, their guesses, their presumptions, but even though the facts may not matter to the majority, 97% of the other facts do matter to the American people. So my problem is this. As the ranking member of this committee, one of the oldest, most should-be fact-based, legal-based committees we have here, where impeachment should have been all along. I have a group of members who have no idea where we're headed next. I bet you, though, if I ask the majority members outside the chairman, they don't have a clue either. Very much one. Because if they haven't, they should share it. Because this is not a time to play hide the ball. This is not a time to say, we're going to figure it out on the fly. You're talking about overturning 63 million votes of a president duly elected who is doing his job every day. And by the way, was overseas today while we're doing this, working with our NATO allies. So the question I have is, where do we head next? We've heard this ambiguous presentation But here's my challenge, is I've already been voted down and tabled today. Mr. Schiff should testify. Chairman Schiff, not his staff, must appear before this committee to answer questions about the content of his report. That's what Ken Starr did 20 years ago, and history demanded. I told the chairman just a while ago and a couple of weeks ago when we were doing a markup, I said, Mr. Chairman, the history lights are on us. It is time that we talk and share how we're going forward. I'm still waiting for answers. So, Mr. Chairman, as we look ahead, as the Democratic majority promised that this was going to be a fair process when it got to judiciary for the president and others. The president, and you may say he could have come today, what would have this done? Nothing. There's no fact witnesses here, nothing to rebut. In fact, it's been a good time just to see that really nothing came of it at the end of the day. So why should he be here? Let's bring fact witnesses in. Let's bring people in because as you said, Mr. Chairman, you said, your words, we should never on this committee accept our entity giving us a report and not investigate it ourselves. Undoubtedly, we're well on our way to doing that because of a calendar and a clock. So, Mr. Chairman, I know you're about to give a statement, and they've worked on it, and you've worked on it very hard, I'm sure. But I want, before you gavel this hearing, before you start your statement, before you go any further, I would like to know two things. Number one, when do you plan on scheduling our minority hearing day? And number two, why or when are we actually going to have real witnesses here that are fact witnesses in this case? When? Or what you said many years ago has faded just like the leaves in fall. I don't really care anymore that somebody else gives us a report. Undoubtedly, Chairman Schiff is chairman over everything with impeachment, and he doesn't get to testify. He's going to send a staff member. But I don't even know if we're going to have a hearing past that to figure out anything that's been going on. So my question as I started out today is, where is fairness? It was promised. It's not being delivered. The facts talked about were not facts delivered. This president, as facts were given, did nothing wrong, nothing to be impeached, and nothing for why we're here. And in the words of one of our witnesses, Mr. Turley, if you rush through this, you do it on flimsy grounds. The American people will not forget the light of history. So today, before you give your opening statement, or your closing statement, before you get to this time, my question is will you talk to this committee? You're chairman. You hold a very prestigious role. Will you let us know where we're going? Or are we going to adjourn from here after you sum up everything, saying that they all did good, and go out from here, we're still wondering? The lights are on. It's time to answer the question. I yield back.
The gentleman yields back. And I want to, before my closing statement, acknowledge that I received a letter today requesting a minority day of testimony under Rule 11. I have not had a chance to read the letter, but look forward to conferring with the ranking member about this request after I have had a chance to review it.
Mr. Chairman, I have a question. You can't review a letter. That is a demand that we have.
The gentleman is not recognized.
There's nothing for you to review.
I'll now recognize myself for a closing statement. George Washington's farewell address warns of a moment when cunning, ambitious, and unprincipled men will be enabled to subvert the power of the people and to usurp for themselves the reins of government. President Trump placed his own personal and political interests above our national interests, above the security of our country, and most importantly, above our most precious right, the ability of each and every one of us to participate in fair elections, free of corruption. The Constitution has a solution for a president who places his personal or political interests above those of the nation: the power of impeachment. As one of my colleagues pointed out, I have in the past articulated a three-part test for impeachment. Let me be clear. All three parts of that test have been met. First, yes, the president has committed an impeachable offense. The president asked the foreign government to intervene in our elections, then got caught, then obstructed the investigators. Twice. Our witnesses told us in no uncertain terms that this conduct constitutes high crimes and misdemeanors, including abuse of power. Second, yes, the president's alleged offenses represent a direct threat to the constitutional order. Professor Carlin warned, drawing a foreign government into our election process is an especially serious abuse of power because it undermines democracy itself. Professor Feldman echoed, if we cannot impeach a president who abuses his office for personal advantage, we no longer live in a democracy. We live in a monarchy or under a dictatorship. And Professor Gerhardt reminded us, if what we're talking about is not impeachable, then nothing is impeachable. President Trump's actions represent a threat to our national security and an urgent threat to the integrity of the next election. Third, yes, we should not proceed unless at least some of the citizens who supported the president in the last election are willing to come with us. A majority of this country is clearly prepared to impeach and remove President Trump. Rather than respond to the unsettling and dangerous evidence, my Republican colleagues have called this process unfair. It is not. Nor is this argument new. My colleagues on the other side of the aisle, unable to defend the behavior of the president, have used this argument before. First, they said that these proceedings were not constitutional because we did not have a floor vote. We then had a floor vote. Then they said that our proceedings were not constitutional because they could not call witnesses. Republicans called 3 of the witnesses in the live hearings of the Intelligence Committee and will have an opportunity to request witnesses in this committee as well. Next, they said that our proceedings were not constitutional because the president could not participate. But when the committee invited the president to participate in this hearing, he declined. The simple fact is that all these proceedings have all the protections afforded prior presidents. This process follows the constitutional and legal precedents. So I am left to conclude that the only reason my colleagues rush from one process complaint to the next is because there is no factual defense for President Trump. Unlike any other president before him, President Trump has openly rejected Congress's right as a co-equal branch of government. He has defied our subpoenas. He has refused to produce any documents, and he directed his aides not to testify. President Trump has also asked the foreign government to intervene in our elections, and he has made clear that if left unchecked, he will do it again. Why? Because he believes that, in his own words, quote, I can do whatever I want, unquote. That is why we must act now. In this country, the president cannot do whatever he wants. In this country, no one, not even the president, is above the law. Today, we began our conversation where we should, with the text of the Constitution. We have heard clearly from our witnesses that the Constitution compels action. Indeed, every witness, including the witness selected by the Republican side, agreed that if President Trump did what the Intelligence Committee found him to have done after extensive and compelling witnesses from the Trump administration officials, he committed impeachable offenses. While the Republican witness may not be convinced that there is sufficient evidence that the president engaged in these acts, the American people and the majority of this committee disagree. I also think that the Republican witness, Professor Turley, issued a sage warning in 1998 when he was a leading advocate for the impeachment of Bill Clinton. He said, quote, if you decide that certain acts do not rise to impeachable offenses, you will expand the space for executive conduct, close quote. That was the caution of Professor Turley in 1998 in the impeachment of President Clinton. That caution should guide us all today. And by any account, that warning is infinitely more applicable to the abuses of power we are contemplating today. Because as we all know, if these abuses go unchecked, they will only continue and only grow worse. Each of us took an oath to defend the Constitution. The President is a continuing threat to that Constitution and to our democracy. I will honor my oath. And as I sit here today, having heard consistent, clear, and compelling evidence that the President has abused his power, attempted to undermine the constitutional role of Congress, and corrupted our elections, I urge my colleagues, stand behind the oath you have taken. Our democracy depends on it. This concludes today's hearing.
Mr. Chairman, I have one thing. Mr. Chairman,
What purpose does the gentleman seek recognition?
Thank you, Mr. Chairman. Pursuant to Committee Rule 8, I am giving notice to intent to file dissenting views to the committee's report on constitutional grounds for presidential impeachment.
Noted. This concludes
Chairman.
today's hearing.
Chairman.
We thank all of our witnesses for participating.
Chairman, I'd ask
Without objection, all
unanimous
members will have
consent.
5 legislative days to submit additional written questions for the witnesses or additional materials.
We have a unanimous consent request.
Too late. For the witnesses
Too
or
late?
additional
It's too late for a
materials for the
unanimous
record.
consent request?
Without objection, the hearing is adjourned.
Yeah, that's
Give me a break.
just typical, isn't it? Just typical.